it to the Secretariat, it benefits Hansard when they're doing the transcription. Mr Walsh or Mr McGinley, do either or both of you have opening statements?
Thank you, Chair. Yes, I'll prepare. I have a prepared statement.
Thank you, Mr Walsh.
On behalf of both Tim and I.
Thank you.
Thank you. On behalf of Maurice Blackburn, thank you once again for the opportunity to present to the committee on this really timely review of the dust and cesspool scheme in New South Wales. Both Tim and I presented to the committee in 2019, and we feel it's a good circularity to come back and present again in 2022. Importantly, in our written submission and any verbal evidence we'll give this morning, our comments and recommendations are based and drawn directly from our experiences from our clients. Indeed, it's their stories and their experiences within the system that drive our push for a better, more compassionate approach to improving the lives of these workers. We know that this year's review is aimed at evaluating the progress of the recommendations made in the 2019 review on the management of silicosis in the manufactured stone industry. Our submission, which you'll have, offered input in relation to the observable success or otherwise of the implementation of the 2019 recommendations. But if we were to draw a couple of overall themes from our response, they would be, firstly, that the implementation of the recommendations has been, across the board, disappointing. Secondly, that it would now be timely for the committee to expand its thinking outside of a tight focus on manufactured stone to a consideration of the impact of silicosis and silica-related disease on a broader range of workers in industries well beyond stonemasonry. Our on-the-ground experience would suggest that important, straightforward and beneficial recommendations from the 2019 review have not been actioned or not been actioned effectively. This is particularly noticeable in some of the more important findings from that review, such as the implementation of free screening, which was recommendation 2, improvements to retraining, which was recommendation 4, the development of a registration or licensing scheme for the manufactured stone fabrication industry, which is recommendation 8, and the introduction of a ban on dry cutting, which was recommendation 9. In our submission, we awarded the government's response to the recommendations as disappointingly a D-. We maintain that there simply has not been sufficient urgency applied to the implementation of what could be life-saving measures explicit in these recommendations. Maurice Blackburn, of course, is pleased to offer our experience and expertise to the committee, and we commit ourselves to supporting the work of the committee well into the future. With those opening remarks, we thank you once again and welcome any questions.
Thank you very much for that, Mr Walsh. I'll now pass to the committee for questions. I am looking for the first person. So, Mr Diadam, would you like to open the questioning?
Yes, I'd like to perhaps direct a question to both panellists. Thank you also for your attendance today. Look, I wanted to ask you about your observations on recommendation 8 in relation to the committee proposed a registration scheme. In Victoria, they've gone much further than that. They've introduced a comprehensive licensing scheme. Can you perhaps make some observations about what you've seen from clients in Victoria and the impact of that initiative from the Victorian government and why New South Wales should perhaps consider following suit?
Happy to answer that, Mr Diaz. It's time for Maurice Blackburn. From Maurice Blackburn's point of view, and I'm sure this is shared by ALA, that the Victorian introduction of new regulations, which covers the field for silica and silica exposure in all workplaces, not just stonemasonry, is really the gold standard in Australia. And our fervent hope is that those recommendations and that regulation is applied across all states and territories in the nation. It's an obvious step to be made. It's obvious that silica-related disease and the problems stemming from excessive exposure to silica is not just captured and confined to the stonemasonry industry. And these issues are huge. Young clients are getting affected, tremendously so, by all manner of silica-related disease. And so positive, progressive action needs to be taken in a regulatory sense immediately. And we hope, as I said, that the rest of the states and territories in this country follow Victoria's lead in this regard.
Ms. Wade, you have
Joanne Wade for ALA. I would support what Jonathan has said, and I suggest that the Victorian system should be replicated in New South Wales, and I'd echo my colleague's words.
Can I ask you, in the Morris Blackburn submission, you I think you referred to the Dust Diseases Act as being antiquated or archaic, I think is the wording you use. Can you perhaps elaborate further on the elements of the Act that you think need attention?
Good morning, this is Tim McGinley from Morris Blackburn Lawyers. I thank the honourable member for the question there. Just before I answer that question, I might just add something to what was asked previously before and just say that in terms of introducing a licensing or registration system in New South Wales, will go a long way in allowing the other recommendations made by the committee to be met as well. If there is a licensing and registration system, it'll make it a lot easier for organisations such as iCare to undertake screening if they know where those employers are located and who they are, as well as allowing any of the safe work regulatory bodies and to be able to conduct proper inspections and enforcement of mechanisms if they know where they are. But turning to the Honourable's second question about the state of the Dust Diseases Act, the problem with the Dust Diseases Act can probably be it can probably summarise in two different points. First of all, the particular diseases compensated by the current wording of the Act are limited to a number of named diseases in the Act, and these very much reflect the medical science at the time that the Act was implemented and not been updated. There are now a number of diseases that are now known to be linked to silica and other dust exposures in the workplace, which are not listed in the Act. And as a result, people who suffer these diseases, who are very much being caused by workplace dust exposure, essentially fall through the cracks. And a couple of examples include people who get silica-induced sclerodoma. So that is a connective tissue disease caused by exposure to silica dust. So while silicosis, being a disease that affects the lungs, is covered under the Act, those who develop sclerodoma are not covered under the Dust Diseases Act because it's not a named disease under the Act. So that's one example, simply that the diseases don't reflect all the known diseases now that can be caused by dust exposure. The second way that the Act is a bit antiquated is in terms of its compensation scheme. The way that compensation is paid under the Dust Diseases Act is very much aimed at the more traditional dust diseases that have been seen, such as asbestos-related diseases and silicosis and silica-related diseases that occur once a person's already in retirement. That is, it's not well designed for people who develop a disease while still in their working life. The compensation that is paid in terms of weekly compensation, while it is good for someone who's already retired, is not good for someone who's already working in the prime of their life and might be earning a high income. It also doesn't provide proper resources for retraining into other areas if people need to leave the industry. And this is probably all a result of it. When the Act was designed originally, it was considering people who had already finished, were near the end of their working life or already retired, as these traditional diseases often affected people. But that doesn't reflect the people who are now being affected as a result of accelerated silicosis.
Can you elaborate just on that point about the retraining? So what kind of benefits are available for retraining and redeployment of younger workers?
So currently, iCare does have a system for vocational rehabilitation. That is really limited to educating people on how to go about finding another job once they've suffered a workplace injury such as a disease. The problem with that with the system is twofold. First of all, many people, especially stonemasons working in the stonemasonry industry today, earn above median wage, Australian median wage, up towards $80,000, and even some senior workers as much as $100,000 and beyond that. That means it's very difficult for them to find another job that pays as well without undergoing significant retraining, such as taking up a TAFE course or a university degree in order to get another job. Unfortunately, not much support is provided under the current scheme for people who do want to undertake retraining. And that could create a barrier for people wanting to leave the industry because they're faced with this prospect that they're not going to be able to get a job with their current training that pays anywhere near as much. They don't have the support available to be able to undertake the training, further training or university or tertiary studies. And as a result, they may make the decision that it's worth staying in the industry, notwithstanding that they might suffer a disease because they don't know how they're going to support their family otherwise with this transition. The second problem with the current scheme when it comes to retraining is more about the compensation aspect. The current scheme, someone's diagnosed with a dust-related, a compensable dust-related condition, they receive a wage replacement allowance for the first 26 weeks, which then goes down to a statutory rate after that. Now, if someone wants to undertake tertiary studies afterwards, that might not be enough to support their family. They've got a young family, for example, while they're doing that. And so they may make the calculation that they can't afford to cease working and to do that. The other problem is that the compensation is related to your level of disability. So if a person finds out quite early on that they have silicosis, for example, before they have significant disability, they may not actually be entitled to any compensation at the time, which acts as a barrier for them leaving the industry to undergo retraining because they won't have an income.
So have you encountered experiences where workers who have been diagnosed with early onset silicosis returning to the workplace rather than finding an alternative?
Yeah. Actually, I might turn to Jonathan with that. I know my colleague Jonathan has one example of that. Before I do, I'll say I actually unfortunately have to see most like the opposite thing occurring, that people don't feel like they can undergo the retraining and don't go into, aren't able to change to another job. So I've had many examples of people being diagnosed with early onset silicosis, either staying in the industry and deciding to chance it for a bit longer to see if they can at least work up enough money to be able to support themselves if they want to restudy or do something else, or unfortunately take a significant pay cut by moving into another industry because they can't find something that they're trained enough to go into, which pays the same.
And yes, just to supplement Tim's commentary, which I fully agree with, in our experiences, and this is common amongst all the states, not just an experience in New South Wales, but whether you're a high income earner or a low income earner, clients of ours have been chancing it. One example of a client he's now 49, about to turn 50. He was informed of his silicosis disease on a review back in 2012. He had young children at that time. He wasn't told he should not return to that workplace because of the dust and the risk that it posed to him with regard to exponentially increasing the chances of a much worse disease. And he's continued to work in that industry, that same level of dust exposure, simply because he didn't believe he could be retrained. And there were no other options presented to him at that time. Very sadly, 6 years later, in 2018, he was then diagnosed with progressive massive fibrosis, the complicated form of silicosis, because of that prior 8-year exposure that he subsequently had to his original diagnosis in 2012. So that is a very live and prime example of the pressure that is placed upon these workers with insufficient weekly benefits available, insufficient retraining options available, and this is now the devastating effect that he's had. And he's moved around project to project now. He's finally sought legal advice and we're assisting him. But that, I think, is a good example of how the system doesn't work for a client and a worker in that particular situation.
Thank you,
Mr. Diaz.
Meeting member.
Thank you, Mr. Diaz. I'm going to pass to Mr. Shoebridge now.
Yeah, thanks, Chair. Thanks to the three of you for your attendance and your submissions. Perhaps starting with you, Ms. Wade, could I ask you what the solution is for that, where you know that you've got a worker who's been exposed, whether it's to manufactured stone or it's silicosis in tunnelling through sandstone. You know they've been exposed. You know that they've got early signs of silicosis or a silica-related disease, but they haven't suffered any incapacity. And basically the law says, until you have an incapacity, we're really not going to shell out any decent money for you. Is that the problem? And B, if so, what's the solution?
It's Joanne Wade for the ALA. Thank you for that question, Mr. Shoebridge. That issue, if they've been exposed to silicosis and they're told they've got early silicosis on their CT scan, no impairment, and it's not really affecting them at the moment, but equally they should still leave the industry. The solution that I see and the ALA sees is that they do need to be supported to leave the industry. So that, in my view, would mean that they should be paid what they were earning for a period of time, and that might be up to 2 years, to help them get retrained. Because we're talking about a cohort of workers who generally have left school aged maybe 15 to 17. They've joined this industry. They've been earning, as Mr. Walsh, my colleague, has said, very good money. They've got young families, and they're at a loss as what to do. So I think the solution is they need to be supported with wage replacement for up to 2 years to get them through a retraining program.
And is that available? It's my understanding is iCare or Dust Disease New South Wales has said the law doesn't allow for that because they're only allowed to pay for incapacity, and it's very difficult to mount the argument to have that incapacity payment for 2 years.
So at the moment, iCare tends to award a 1% incapacity, which means, yes, they've got very, very early silicosis, but technically they're not really impaired. But they award them a 1% impairment so that they then can pay them for the first 26 weeks at what their wage was, and then that does drop down to the statutory rate. That's not enough to support, say, someone in their 30s or early 40s with a young family who might have been the breadwinner earning $100,000. And so...
Yeah. So can I maybe just go to Mr. Walsh and or Mr. McGinley. First of all, do you agree with that analysis? And then if so, should we be recommending that there be a 2-year transition benefit payable to particularly move, workers who have early onset but minimal or no measurable impairment, and we change the law to allow that to happen?
Yeah, definitely, Mr. Sturridge. I agree with what Ms. Wade has indicated and with the proposition you put in your question. Undoubtedly and very clearly, a change in the law is required to ensure that these workers get compensated for a period of time. By way of comparison, in Victoria, there's a 2-year lost wages, 126-week period of time where workers diagnosed even with nil disability silicosis are paid back wages. That is even debatable whether the 2-year period is sufficient. Compared to Queensland, up to 5 years of wages can be paid before that particular worker is exited from the scheme. The problem lies in 2 years may well not be enough to properly understand the nature and extent of the silicosis diagnosis for that particular worker, and particularly it becomes problematic where there are secondary diseases like, for example, a psychological condition, anxiety, depression, adjustment disorder, which is extremely frequent, particularly in younger workers with a diagnosis like this. And those diseases, those particular injuries take a long time to resolve, well beyond 2 years. And the secondary issue we're seeing, as we've mentioned in our submission and verbally already, is silica-induced autoimmune diseases, scleroderma, rheumatoid arthritis, lupus, renal failure. These particular conditions also take a long time to manifest themselves. And so oftentimes we've found that a 2-year period, particularly for clients based in Queensland, is insufficient time to understand the nature and extent of their injuries. So we would certainly advocate for a longer period of time, beyond at least 2 years, but it should be longer to allow these workers to get the medical attention they need, understand the nature and extent of their injuries, and be presented with options regarding retraining or medical treatment which is fit for purpose for their individual situation.
Where a condition, such as one of those secondary conditions, an autoimmune response or similar, is not compensable under the dust diseases legislation, does that mean the worker then has to make a separate claim under the workers' comp legislation? How is that compensable to them?
That's exactly how a worker needs to address that particular issue, Mr. Shrewsbury, and it's very problematic when we're coming to representing and pursuing cases on behalf of workers who have both conditions, silicosis, a very clear lung disease, and a secondary autoimmune disease like rheumatoid arthritis. The law is not clear, as to how the courts would award damages in those particular circumstances, but on a practical level, that particular worker, that client needs to make two separate applications, both to ICARE, to different arms of ICARE, one to ICARE dust diseases for the silicosis component, then one to ICARE generally for the work-related component, that being the autoimmune condition. We've proposed in our written submission a very simple fix, an update the definition of a dust disease to include any pathological condition caused by exposure to dust. That would cover the field, that would cover all the issues around dust-induced COPD, dust-induced emphysema and bronchitis, and the autoimmune conditions. It just seems illogical that both ICARE dust diseases care can't cover the field for all related injuries.
My final question before I hand over, I know other committee members have questions. Ms. Wade, do you support that descriptive addition to what is a compensable dust disease injury, instead of just the list, but you have a descriptor that says those diseases, including secondary diseases that flow from exposure to dust?
Yes, I definitely support that.
Could I ask you, if you wouldn't mind, on notice, to have a look at the proposed recommendation that Mr. Walsh has just referenced, and see if there are examples around any other jurisdiction that we could pull off the shelf. And I might ask you, Mr. Walsh, the same on notice.
Thank you very much, Mr. Shibridge, for that. I'll now pass to the Honourable Greg Donnelly.
Thank you, Chair. Thank you, witnesses. My questions are general in nature, and I'll direct them to witnesses from both respective organisations, the ALA and Morris Blackburn Lawyers. Can I first of all thank both organisations for putting in your submissions. It's so important to actually have quality information before us to help us guide in our thinking and ultimately award preparation and recommendations. Can I say that I think there are members around the table, I don't seek to speak for all of them, but I think the majority who do say and would say they share frustration about seeing the slowness of the progress of the dealing of this matter. And I note particularly in the opening statement from Morris Blackburn Lawyers some reflection on the failure to proceed with significant recommendations from the 2029 inquiry report, particularly around recommendations 2, 4, 8 and 9, which brings me to this point. When we last looked at this important policy area, there was some tepidity, I think, in acknowledging that what we were looking at and staring at right in the face was something that potentially was our asbestosis issue to deal with today. In other words, this is what's before us to deal with. And there were some witnesses who were reluctant to compare what we're looking at to what in fact we saw back then. Can I invite the witnesses to comment about, in fact, that we have to really make a step change in our thinking that clearly this is equivalent, at least in terms of its impact, to what we saw then, and time now has well passed to move to implement these structural changes to our legislation that you've outlined.
Could I ask one of the witnesses, perhaps Ms. Wade or Mr. Walsh, Mr. McGinley?
G'day, this is Tim McGinley from Morris Blackburn Lawyers. Thank you, the Honourable Member, for the question there. I believe we made some submissions regarding this particular issue during the last review, and specifically this similarity drawn between the asbestos issue of the 1970s, 1980s and what we're facing now. I would say that certainly in terms of the public health risk, in terms of this product presents, certainly yes, this is a test of similar magnitude in terms of public health response, although it presents much different issues that have to be dealt with compared to what we did with mesothelioma, with asbestos-related diseases. First of all, most of these diseases are striking people in the prime of their life, rather than asbestos-related diseases, which often strike people once they're already retired. And so there is potentially much more significant economic consequence both to an individual and to the larger compensation and public health system at large, presented by accelerated silicosis that wasn't seen during the asbestos, the greater years of the asbestos-related claims. The advantage I think we see here is that compared to what happened with asbestos, we're still very much at the beginning of this particular epidemic, and so steps can be taken now in order to prevent it becoming much more worse, as long as those steps taken so that we don't face the same human casualties that we did as with asbestos-related diseases previously. So yes, this should be seen as a public health emergency in the way that the asbestos-related disease were, but I think we are in a good position to be able to take steps to spare a lot of lives if we take steps now. If we don't take those steps, potentially the economic and human consequences of this could be worse than what we've seen with asbestos.
Thank you. I'm just wondering whether Ms. Wade, you'd like to comment about the potential dimension of what we're looking at. In other words, it is perhaps in some sense one could consider early days, but if one considers that we are now in 2022 talking about a 2019 report with recommendations, they are precious years that have slipped away.
Ms. Wade, it's Joanne Wade for the ALA. Thank you for that question. I know in the National Task Force report, they did make a recommendation that if the industry cannot be cleaned up by 2024, then a ban should be placed on the engineered stone products. So that's only 2 years away. So something does need to be done to make sure that the industry is complying, introducing the registrations and the licences, making sure the factories are inspected and complying with dry cutting bans, making sure that dry cutting is not taking place when they're installing these bench tops. So yes, 3 years have slipped away, and there is an urgency around it because these young workers are still being diagnosed with the silicosis and these and other diseases.
Thank you. Chair, I might allow the Honourable Mark Buddigig to provide some time for interquestion.
Thank you, Mr. Donnelly. I was actually just going to offer first to see if the government members had any questions that they wish to ask before I go to Mr. Buddigig.
Thanks very much, Mr. Chair. I've got a couple. Just looking at in terms of the definition that you've advocated, how many people are falling outside of the scheme at the moment because of the definition? What are you seeing in terms of people that are coming to you that can't access the scheme because of the current definition?
Mr. Farrell, it's Jonathan Walsh from Morris Blackburn. The problem with that answer to that question I'd like to give is that we simply don't know. There's been no comprehensive screening of all industries across the nation, particularly in New South Wales, to understand the nature of silica-related disease. The comparison we have to asbestos and the asbestos wave of disease is just, and I certainly agree with it, that when we face the silica-related disease problem, it's massive, but we don't know how big the problem is. But the asbestos disease wave could follow the product to then identify the industry and the particular worker as to who would be at risk. The difference, and the fundamental difference with silica, is it's not just engineered stone. It is naturally occurring silica, which is disrupted and disturbed every day of every week in many particular industries, including tunnelling, road construction, metalliferous mining, quarrying, general construction, abrasive blasting, concrete manufacturing, and many, many other industries where we don't even know that silica product has been put into the manufacturing process. We can give anecdotal numbers of clients who've fallen through the cracks. but the problem is large based on the corporate samples that we have of clientele bringing these cases presently. But the problem is we can't effectively answer that question as to the extent of the problem.
Thanks very much, Mr. Walsh. And I know the Australian Lawyers Alliance didn't make the same concrete recommendations when it came to the definition, but did raise this issue as well in terms of the definition. Do you have any comments to make on that point either?
I would only add that I've seen the reports on that have been published that Hsrs has undertaken an actuarial study in relation to the definitions and the diseases, and I think ICARE should respond to that report and make recommendations to the government about the definitions and the diseases to be included.
Thank you very much. And then just another question with respect to recommendation 2, your comments on recommendation 2, this is to Maurice Blackburn, with respect to the free screening service for all workers. Have you got any, I know that you say that you're unaware whether a free screening service for all workers has been conducted, but have you had any clients that have had experience with either the lung bus that's been provided or with the iCare Pitt Street service either? Has anyone provided you any feedback on usage of those facilities from iCare?
Good. Hello, this is Tim McGinley from Maurice Blackburn. Thank the honourable member for the question. Yes, certainly we have had experience with people who have used both the lung bus and the iCare's facilities in the CBD. And generally speaking, the outcome of those have been good. The clients find those highly assist them greatly and have led to lots of diagnoses. The issue with those is that the lung bus can only be in one location at any one point in time, and the facilities in the city are right there in the city, whereas the industry is spread throughout New South Wales. The current scheme is that the iCare provides subsidised free screening for employers that have under 30 employees and subsidised screening for people over that. But unfortunately, the way the system works currently is it's still on the employer to organise screening. Despite the fact we have had clients who've had experience with the lung bus and with iCare facility in the cities, a majority of the clients over the last 2 years that have come to us diagnosed with silicosis as a result of manufactured sodium exposure have come to us as a result of organising screening themselves. Usually they come from workplaces where no organised screening has been organised, but they've seen something on the news or heard about a colleague who's been diagnosed with silicosis and go to their own GP or to a respiratory physician and get a referral themselves, and as a result get a CT scan. And while it's great that employees are getting the message and getting themselves checked out, it should not be left to the employee to have to do these in the circumstances. And certainly most employees, when they organise it themselves, and particularly if they don't have private health, end up paying an out-of-pocket cost if they go to a specialist or if they have to have a CT scan, which can equal hundreds of dollars. And so while we see the people who do go and get scans themselves that come and get diagnosed and come to us to advise, we don't see the many more people who that cost barrier might prevent them or deter them from going and get screened, and whose employers have not organised screening for them.
So outside of the heavily subsidised screening processes, what sort of costs are injured workers or potentially injured workers incurring for these screenings? I know you talked about the CT scans and that, but what are we looking at in terms of the quantum?
Look, that varies from location to location, depending on what a particular service charges for an elective screening. So, but usually the two screenings, the two costs that might be incurred is if the person goes to a respiratory physician, a specialist, and doesn't have private health insurance, or their private health doesn't cover the entire gap, as well as if they go for a CT scan. But usually we're talking in the hundreds of dollars for a screen.
Mr. Farlow, thank you very much, Mr. Farlow. Mr. Budgig, we've only got a few minutes left, so I'll give you the opportunity to ask a quick question, and then we will have to draw this session to a close.
Thanks, Chair. Look, I've got a few, but I'll sort of zero in on one particular one that struck me when you mentioned the Victorian jurisdiction as being the gold standard. I think the general view from the submissions I read is that Queensland is much better than New South Wales as well. Presumably there's a proliferation of screening and testing down there, and I was just interested in any commentary around the evidence coming out of what appear to be better systems in those states, is it the case that we actually get more evidence of silicosis contracted diseases as a result of a more transparent regime where people are coming forward and getting tested and employers are encouraging it, so that the evidence actually shows that there's more incidence of silicosis in those states as a result? And if so, what does that imply for, I guess, some employers may want to use that as evidence that it's not necessary to go down that path because we've got lower rates in New South Wales. Is there any sort of, is that the general trend about in terms of what's been happening?
Yes, Mr. Jonathan from Morris Blackburn. I can certainly speak to the Queensland experience. So they WorkSafe Queensland, in conjunction with WorkCover Queensland, screened 1,200 stonemasons, all stonemasons in the state, of which around 25% were diagnosed as having silica-related disease. And we anticipate that type of 1 in 5 worker with a silica-related disease is probably going to be reflected throughout the other industries too, metalliferous mining, tunnelling, road construction, things of that nature. It is true that the more you look, the more you will find, but that can't be a reason for New South Wales employers to refuse to object against the full screening of all workers in affected industries. As my answer to the question previously put speaks to, we don't know the extent of the problem. In order to tackle the problem effectively, we need to know the nature and extent of the problem. And without proper comprehensive screening industry-wide, we will never know that answer, but we do need to know it. So all the flow-on effects to the health system, in particular around cost, treatment, things of that nature, the economic impact on incomes, families, mortgages, things of that nature can all be factored in to the whole government response.
Chair, any more time?
I was just about to indicate to members that we have run out of time, and if there are questions that members may have that perhaps they could go on notice. I'm sorry that we are quite tightly packed today, and I just want to try and keep us on schedule as much as possible. So I'd like to thank the witnesses for attending the hearing today. The committee has resolved that answers to questions on notice will be returned to us within 21 days. The Secretariat will be in contact with you about those questions on notice. We'll now just have a very quick transition to the next set of witnesses, and we'll do an audio check before we start to go back to the questioning. In the lobby. Can I please ask Mr. Krause if you can hear me and if you're able to respond just with an audio check? I did, Mr. Krause. Could I ask you again, please, just to check your audio and confirm that you can hear me?
Yes, I can hear you. Can you hear me okay?
I can. We are getting a little bit of feedback as I speak. It's being repeated back.
Okay. I'm not quite sure how to do that, fix that.
I suspect you might just go to mute after.
I'll just mute in between discussions.
Thank you very much. Mr. Donovan.
G'day guys, how are you going?
Good, thank you. Mr. Krause, have you... Oh no, you must have muted now, I'm guessing. Because yes, we were getting feedback right up until you hit me the mute. We will now welcome our next set of witnesses. Could I ask each witness to swear either an oath or affirmation and give their name and position title? I'll start with you, Mr. Krause.
Thanks. It's pronounced Cruz, by the way.
Apologies, Mr. Cruz. If you could swear your oath or affirmation and just give us your name and position title.
Yes, my name is Ben Cruz. I work for the CFMEU. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Mr Donovan.
My name's Chris Donovan. I'm the National Work Health and Safety Director at the Australian Workers Union. I speak defamation, solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Do either or both witnesses have a short opening statement? I'll start, Mr Donovan, since you... Oh, actually, Mr... Cruz, sorry.
Yes, I'll give an opening statement. Thank you. The CFMEU remains concerned about the high incidence of silicosis in New South Wales and lack of action in banning high-risk, high-silica content products such as manufactured stone. The shocking truth of this crisis is described in the federal government's National Dust Diseases Task Force report of June 2021 that estimates that nearly 1 in 4 engineered stone workers who have been in the industry since 2018 are suffering from silicosis or some other dust-related disease. So it's extraordinary that the submissions and responses to this inquiry provided by our New South Wales safety regulators are so banal. The Parliament's taken some important steps over the last 12 months to improve regulations, but more needs to be done by Parliament, and these initiatives are outlined in our submissions. Most important of all is a ban on the use of high-risk manufactured stone products. The data from Safe Work continues to demonstrate extraordinary levels of non-compliance with work health and safety regulations. This partly explains the incredibly high incidence of illness and the significant mortality rate. In the case of manufactured stone, as with asbestos, the nature of the substance is so inherently dangerous that workplace controls aren't the answer and the substance just has to be substituted for something else. We remain concerned that much of the Safe Work response appears to be directed towards the fabrication side of the industry. There have been inspections in the construction industry, however, it simply isn't clear to what extent inspections are being carried out where the most high-risk work is performed in installation settings. We're also concerned about responses from Safe Work to the pre-hearing questions, the extent to which there can be confidence that dedicated teams of inspectors will be out doing this work and not be distracted by other perhaps less challenging obtaining jobs in liquor and gaming. The results of the case-finding study reported by Safe Work are terribly disappointing. As it was anticipated by the last parliamentary inquiry, the case-finding study should have involved cooperation between safety and health regulators and professionals. What appears to have happened instead was that a consultant was employed to review the existing data. Wales Health has developed sophisticated skills in forensic contact tracing. These skills should have been used in the case-finding study so we could follow the path of toxicity from import to fabrication and installation. But as it was implemented by Safe Work, the case-finding study appears to have been not much more than a data analysis and in our view did not meet the requirements of the regulations. Interestingly, the submissions from Caesarstone and Smartstone go some way towards recognising that a ban of, quote, certain high RCS content engineered stone may be considered if reforms do not tackle the re-emergence of silicosis, end quote. Given the privileged knowledge that the manufacturers and importers have about the content and nature of their products, perhaps they see the writing on the wall, and if so, one wonders why there's such willful blindness on the part of government and regulators about getting on with implementing a ban. The importers and fabricators argue that time is needed to measure the effectiveness of recent regulatory reforms and propose a licensing system. However, I've attended enough of these inquiries to be confident in saying that enough time has already passed and that action is taken on the ban now. Imagine the outcry if 1 in 4 dentists, lawyers or politicians were being poisoned by their working environment. Things would get done pretty quick smart. Manufactured stone isn't essential to our economy. It's not an essential product in steel making or agriculture or future space exploration. It's just part of an architectural It's only existed since the 1990s and eventually will pass like less destructive trends such as the vertical grills of the 1970s. We need to have courage to take action. The CFMEU is also concerned at the lack of engagement from the regulators. SafeWorks' submission to this inquiry is half-hearted at best. The regulator says they're about to roll out the response to the National Code of Practice and are liaising with industry about that, but there's been no communication with the CFMEU at all on policy or practical matters in this area since the abrupt dismantling of the manufactured stone task force over 2 years ago. We actually do have skills and knowledge in this area and, for example, have dozens of health and safety representatives representing thousands of workers on building sites across the state. Notably, the Royal Australian College of Physicians also appears concerned about the lack of consultation. The 2019 task force discussions were challenging and contestable, but SafeWork now appears to be so close to the manufacturers that consultation has become a process of speaking into an echo chamber. Real change will only come through engagement with a broad range of stakeholders. There are some important regulatory changes that can be made, and I'm happy to talk about those further to the inquiry. There needs to be more research about the toxic nature of these ingredients and the development of new monitoring technology to support the further halving of the workplace exposure standard. I note that Hsrs on research initiatives funded by the Dust Diseases Board. As a member of the Dust Diseases Board, I'm not here to speak today on behalf of the board, but it's common knowledge that while over the last couple of years the board's been able to direct some focus funding towards silica-related research, from time to time these focus areas have had to change so that progress doesn't fall behind in other important areas such as mesothelioma treatment and quality of life research. There's a strong argument for the government to support a specific funding initiative directing and tackling the causes and prevention of silicosis and technical advances in air monitoring. Thank you.
Thank you, Mr. Cruz. And just in relation to your opening statement, I note you were reading from some notes. If it was a pre-prepared statement, would you mind emailing it through to the Secretariat? Because we did have a number of audio issues while you were broadcasting then, and there was some dropouts. So just for the benefit of Hansard and perhaps other members, if it can be emailed through, we can pass it over to them for the transcript. Mr. Donovan, can I invite you to make an opening statement, please?
Yes, thank you. The Australian Workers' Union represents members in a diverse range of industries. Our members in tunnelling, quarrying, cement work, mining, construction are among those facing the greatest risk from silica exposure in the workforce. It is noted that the current review is concentrated on the engineered stone industry, as were prior reviews, and while the AWU understands there is a particular crisis in this industry and supports swift preventative and regulatory action, including banning of the engineered stone itself. However, the focus of the New South Wales government must not be limited to the engineered stone industry alone. Silica dust does not discriminate based on what industry a worker is in. Workers exposed to silica dust in tunnelling, quarrying, cement work, mining, construction and other industries must be given equal consideration for the purpose of this review and subsequent recommendations. New South Wales will see cases of silicosis rise in the coming years and decades if swift preventative, regulatory and compensatory measures are not quickly adopted by governments to protect workers exposed to silica dust. Thank you.
Thank you, Mr. Donovan. I'll start the questioning with the Honourable Anthony Diadam.
Thank you, Chair, and thank you, Mr. Cruz and Mr. Donovan, for your appearance today. Look, I might start with Mr. Cruz. I wanted to ask about the workplace exposure standard. It's been reduced to 0.5 milligrams per cubic metre. Is that a safe level now?
Well, the reports that the National Inquiry heard last year were that a truly safe level won't be implemented until the WES is reduced to 0.02. And the difficulty is that the technical know-how just doesn't exist at the moment, except with extraordinary expenditure to actually measure levels at that safe standard. So that process at the national level of the reduction of the WS has been postponed until the technology catches up. The point I make is this, that if this substance, particularly with engineered stone, is so dangerous that can kill you at such small levels of exposure that can't be presently measured, surely that is one of the strongest arguments of all for the substance to be banned. I mean, the admission on the part of the National Task Force is that we can't actually monitor for safe levels, and so therefore the present WES of 0.05 is actually more than double what is understood from a health perspective to be the safe level.
So you're effectively saying workers aren't safe unless the workplace exposure standard is at 0.2, and in that case, the product can't be counted safely.
That's right, and the safe work statistics from September last year indicate that 16%, 24 out of 147 businesses were not complying with the new workplace exposure standard. So there's an extraordinary level of non-compliance with a standard which is more than twice the density of what a safe exposure would be. So it's just not possible to control this substance other than by substituting it for something else.
How would you measure the workplace exposure in an installation context?
Well, our concern is that that's just not happening. There are methods of measuring exposures in installation contexts, and of course hygienists do exactly that. But our concern is that the focus with safe work is on working with the fabricators, which is where the big money is in terms of the importers and where most of the conversations appear to be happening. And we're just not confident that enough monitoring work and inspectorate work is being done at the installation level, which is where all the small businesses are, which are not as strongly unionised, so we don't see as much of those people. And we think that's where a lot of the disease and deaths are occurring.
How practical is it for safe work to be inspecting for, say, dry cutting in an installation context? I mean, these guys are out in homes, new constructions in the housing sector. I mean, how does an inspector monitor and enforce the dry cutting ban in that context?
Well, it's just not practical, and that's why asbestos was eventually banned, because eventually it dawned on everyone that the substance just can't be satisfactorily controlled. You can't follow the installers around and make sure that they actually comply with the regulations.
Mr. Dowdham, do you mind if I just pass the questioning now to Mr. Buttigieg, then Mr. Shoebridge, and I'll come back to you if there's a little bit of further time. I just want to make sure everyone has the opportunity to ask a question.
Well, look, if I could just ask one further question about the Victorian regulatory regime that's been put in place. What's your view about that? And do you think that the licensing, that scheme licenses employers and subcontractors? Do you think the licensing regime should extend to individual workers who are handling manufactured stone?
Well, the Victoria is the best of the licensing schemes that are around. One of the impressive things about it is that it follows the chain of supply, and so it does to a degree have this sort of tracing element. It has requirements about training, and of course the employers and the installers have to be licensed. But look, our view is that's not sufficient. The substance itself should be banned.
Mr. Buttigieg.
Thank you, Chair. Perhaps to Mr. Cruz first. In terms of the banning edict, which, I mean, I've got some sympathy for, given the experience that we've had with asbestos and mesothelioma over a protracted period, where you've got a substance embedded all through the economy and then you've got the spectre of it becoming what they call friable, you know, whereas always in the hierarchy of controls, you eliminate the hazard if possible. I just want to get your feeling, though, has this been done in any other jurisdictions, a ban, like either interstate or internationally?
I'm not aware of bans being put in place in other jurisdictions. What I am aware of is that the companies that are making and supplying these products are international conglomerates, and they have extraordinary political and market power, and so governments do appear to be influenced by that.
So what would you say to one of these conglomerates who presumably one of their arguments might be, look, once it's manufactured and polished, unless it's disturbed, which is highly unlikely, it no longer poses a threat. So if we can put in appropriate PPE and workplace safety measures to protect workers, then that will solve the problem. What's the response to that?
Well, the problem is that the evidence is that you can't control the installation process because, and particularly with the small installers who are doing domestic work and even the installers on large building sites, the controls simply aren't implemented. So I know that's the argument that's put forward, but that's the data from the few inspections that are occurring in New South Wales just doesn't simply reveal that.
And is it a case that you've got a situation where it's a simple calculus of economics? In other words, I don't know what do they say the stone industry's worth in Australia to the economy? Do we know?
Off the top of my head, I can't say that. That's not really a field. What I can say is that all of this stuff is important. So it's say if you make a comparison to the asbestos industry, which was shut down. I mean, that was an industry that involved mining in Australia, jobs in mining, jobs in transport, factory jobs in packaging and distribution. Here, the process of substitution really wouldn't be that difficult. There's many other products that can replace this, whether they be wooden products, steel products, other conglomerates, and even the manufacturers themselves are starting to highlight the idea of low silica products that may be can be manufactured to perform this task.
Okay, and perhaps just one more, so I'm conscious that my colleague, Mr. Shoebridge, wants to ask a question to Mr. Donovan. From your submission, you make an emphasis on the fact that this is not just about the manufactured stone industry, notwithstanding the crisis in that industry, but there's a whole range of occupations outside tunnelling and whatnot that are just as exposed. Can you give us a sense of the percentage of workforce exposed vis-a-vis the manufactured stone industry? In other words, the breadth of the problem outside manufactured stone is outside.
Yeah, look, I don't have that data at my fingertips, but obviously the construction industry more generally is a much larger industry, and I know that the Victorian scheme solely focus on manufactured stone, but focuses on silica regulation more generally. And it's the case that over the last several decades, there's been a much higher incidence use of mechanised tools. The AWU obviously has experience with the tunnelling side of things. There's been a huge increase in silica exposure in those environments, and I'm regularly dealing with members who have discussing silica exposure in that environment that's much higher than it has been in recent decades.
I was just going to pass to Mr. Donovan for a quick answer, if that's okay, and then Mr. Shoebridge will have the call.
Yes, certainly. Well, we're certainly terrified at the potential rate of silica exposure to workers outside of the engineered stone industry. I think I make reference in my submission to basically number of workforce participants, which was approximately, from, if I recall correctly, around 600,000 Australian workers currently exposed to silica dust, and stonemasons do make up a portion of that, and obviously their exposure is arguably greater, as we've seen here in the number of cases of silicosis in those workers due to the materials worked with. However, if we're looking at tunnelling and quarrying in particular, we are extremely concerned, given the large quantity of workers in those industries, that if this matter isn't dealt with across the board, then we're likely to see silicosis cases rise substantially moving forward.
Thank you for that, Mr. Donovan. I'll now pass to Mr. Shoebridge, and then after that I'll give the government or the crossbench an opportunity to ask some questions.
Cool. Look, thanks, Chair, and thanks to the two of you for your evidence today and the work both of your unions do on safety on the ground. Have you had the opportunity to read the iCare submission, Mr. Cruz?
Yes.
Yeah. What do you make of finding itself in a situation where it's got a 59% fund, and what's led to that being, seems higher claims management, stuff up in terms of past underpayments. What do you make of that?
I'm sorry, I did miss a little bit of that. Were you talking about the underpayments issue, Mr. Shoebridge?
Well, iCare says that the dust disease scheme has only a 59% funding ratio, with $1.2 billion in funds under management. As when I do the numbers, that's a deficit of some $833 million. And they say that the scheme's liabilities have been adversely impacted by a higher than expected number of claims, an increase in expected claims handling expenses, as well as allowances for remediating past underpayments to some workers and revising future payment practices. A lot of that seems to be stuff-ups from iCare, but I could be wrong. What's your view?
Yes, well, look, we've addressed that at point 11 of page 16 of our submission. There have been concerns with payments. There were some retired and disabled workers that were paid a statutory rate rather than their actual rate of pay for 26 weeks of incapacity. I mean, that is a stopper. There are also overpayments made in some circumstances. And rather than focusing on the past, I'm more concerned to look at the future. One of the concerns that we have is that the standard iCare response is to engage external advisors such as PricewaterhouseCoopers to come and resolve these issues. And what clearly needs to happen is that they need to improve their competence within the organisation to actually address these issues themselves.
Mr. Donovan?
Look, I think I'll just echo the comments of my my comrade in the CFMEU, to be honest. It's obviously not too good. And just like him, I think I'd like to concentrate on the future in terms of having these matters resolved. But I mean, all of these things, and it might be a question worth posing as well to the lawyers, given they might have a better sight of that.
Well, one of the matters in iCare's submission is they point out how the underpayments have arisen, how on their fresh reading of the law, some incapacitated workers, their dependents aren't entitled to even the very modest payments under dust diseases, and it really depends upon when you were found to have had your dust disease injury. And they say that they've recommended to government that be fixed by legislation, so that regardless of when your injury is, you and your dependents have the right to the same and fair compensation. Have you been consulted about any amendments to that effect?
I'm not aware of any direct consultation with that, with us about that matter. Look, if I could also just be a bit opportunistic and point to one concern that's in our submission about legal issues. Our lawyers tell us, who represent injured workers, that there's a real problem before the tribunal, Dust Diseases Tribunal, in deregistered companies having to be reinstated through expensive and timely Supreme Court actions. This issue needs to be resolved. I used to run a dust diseases cases myself, and I'm well aware that there's often a real race to get these hearings on because people's health conditions can turn very quickly. Everything needs to be done to streamline the process for people getting their cases heard before the tribunal.
Could I ask you if you could, to just give us a brief additional submission on that point? Because many years ago, when I did practice in this space, I recall those fairly pointless summonses to the Supreme Court with the cost and expense and delay to reinstate a company, purely to have some kind of nominal defendant who is then represented by an insurer. A ridiculous waste of money and time. So if you have a proposed law reform in that regard, it would be great if you could articulate it with some clarity in notice.
Yes, well, I take you to page 17 of our written submission, and the best example of the problem is identified in the matter of Richard's contracting. All of these procedures are relatively automatic, but they involve moving through step by step through an extraordinary number of applications that are costly. I mean, simply put, the Act needs to be amended so that any claim made by a worker on a former employer can be managed and satisfied by naming Hsrs in the proceedings in the Dust Diseases Tribunal without also having to obtain a leave from the Supreme Court corporations list to reinstate deregistered corporate employers.
All right. That seems extremely rational, although it does cut out some work for lawyers. But maybe that should be part of the scheme. Mr. Donovan, do you have a view about the need to urgently implement legal changes, as apparently iCare has informed the government, to ensure that no dependent or worker is worse off with a dust disease claim, just depending on some arbitrary date of their injury?
Yes, certainly, and I think we touch on this in the submission. I can only speak really anecdotally. We have a number of people who would fall into that category. If you look at the workforce in general, they are typically, the old sort of system of the breadwinner, basically, and the worker who, the partner who is not working typically stays at home to do sort of domestic duties in that fashion. So when we see instances of silicosis occur, it's typically quite harsh, and it is actually discouraging people and workers who we're aware of actually coming forward who are already displaying symptoms of silicosis or potential lung diseases, because there is lack of faith in the system itself, which we are concerned about. But certainly, any changes should also include, given what I mentioned before, provisions for adequate compensation going forward relative to their current role, and for that compensation, and also extra support for family members. I think you'll find as well many of the tunnelling workers that we represent are on it's a decent wage, given the amount of risk that their job requires them to do. However, the tunnelling jobs will not be around forever, and typically what we see is a lot of movement within the industry. That is, workers will go from Victoria to Queensland, back down to Sydney to continue to do and work on tunnelling projects, which puts them at further and further risk of developing these sorts of diseases.
Could I ask you both, if you wouldn't mind, just to take on notice and maybe go back and check with other officers what, if any, consultation has happened with your organisations about the underpayments issue? Thanks. And
Mr.
Yes.
Mr. One final question, Mr. Shridge.
Yeah. Assuming that iCare's numbers were right, at least as in the end of December, and that they have only 59% of what is required to meet future claims in their kitting. What's the answer to that? I mean, we've heard very clearly the need to expand the definition of dust disease injury to pick up dust diseases that are otherwise having to be separately prosecuted in the workers' comp space. There's clearly a need to make the law work so that no injured worker or dependent is worse off based upon the date of injury, but there's also a big bloody hole in the finances. How do we square those things?
Well, if I can go first, obviously the hole needs to be filled. I'm not going to propose any specific mechanism, but Mr. Shubridge, the observation that I'm making is this. In the case of silicosis, this is not these are not onsets that take decades to come about. These come on quickly. We've got members in their late 20s and 30s who are contracting this disease. What we need to do is stop people getting it. If we ban this toxic substance, that will stop the problem, and that will also improve the finances of the scheme, which is, over the last several decades, really focused on mesothelioma and asbestos-related diseases, and the silicosis crisis has taken the scheme by surprise. Well, it did a few years ago, but this is the third or fourth of these inquiries that I've attended. We really need to get the prevention sorted out and fill the economic hole. If we do that, things will look after themselves. Finances and safety go down the same path. You keep injured workers safe. Mr. Donovan?
Yes, look, I agree with Ben on that one. I'd also just like to say that there are some instances of silica that are being developed, or silicosis that are being developed that has quite a long latency period as well. So, I mean, if there is lack of funding, then, I mean, you'd want to really be looking to the future, not just in the next 4 years or whatever the next election cycle is. You'd want to be looking in the next 10, 20, 30 years, even if the tide is stemmed currently, that's not currently happening, or fast enough anyway. If the funding isn't there and available for people who will contract silicosis going forward, we know that's going to happen, then that just raises a whole bunch of questions in terms of how these people are going to be adequately looked after under the workers' compensation provisions which they're entitled to. There should be far more attention put on this matter. It forms a part of the entire strategy, which should be prevention, number one. Number two, regulatory change, and number three, adequate workers' compensation for measures that are available to workers. If that doesn't happen, we're in a lot of trouble going forward.
Thank you for that. I'll now pass the questioning to the Honourable Lou Amato.
Thank you, Chair. And firstly, thank you to each one of you for being here today. This is a very important issue indeed. Look, I don't mind to answer this question, or we can answer the question. Look, I understand that a lot of people engaged in the stone industry come from non-English speaking backgrounds. Are you aware of what has been done to ensure that business owners and workers understand the hazards and also the safeguards that need to be undertaken to ensure workplace safety? And also, you know what safeguards have been implemented in the stone industry up to date? Also, since the last inquiry?
Well, Mr. Amato, in my role on the Dust Diseases Board, the board wrote to the government when this crisis first appeared and called on the government to increase the amount of advertising and education in non-English speaking languages. And some action was taken initially on that. I'm just not sure of to what extent there is continuing expenditure on that front. The big concern that we have at the moment is the lack of engagement with the broader stakeholders. So it's just extraordinary that, Safe Work haven't come near us for several years now, given the high level of engagement that we have with workers in the industry, all our health and safety representatives who live and speak these community languages every day in the workforce. So you can only get so far with advertising and brochure to engage with workers, and you also need to make sure that the regulators engage with the workers' representatives.
Okay, and I guess the unions would be limited in their access to a lot of these small businesses.
Yes, but it's, it's known generally that small businesses tend to be less heavily used. In the larger enterprises, it's now a mandatory provision in CFMEU enterprise agreements that the training that employers conduct training on specifically directed towards silicosis risks, and that's a very practical effort that we've made sure is implemented at all the major work sites where our members are. In submission, we've also made some very specific comments about training, with the recommendation that the regulation be amended to require businesses to provide training regarding the health risks associated with crystalline silica exposure, similar to those in the Victorian regulations, and to make sure that that training is nationally accredited.
Thank you, Mr. Cruz. Mr. Donovan? Anything further to add?
Look, I don't have anything further to add on that.
Okay, thank you.
You finished your questioning, Mr. Amato?
I have, Chair.
Thank you. I'll just check if the other government members or Mr. Roberts may have anything that they wish to ask. If not, I will go back to Mr. Buttigieg and Mr. Shoebridge.
Thanks, Chair. I just want to sort of try and encapsulate what I think is the key elements of both pieces of evidence. And the emphasis is on, particularly from the CFMEU, but supported by the AWU, is prevention by getting this thing out of the system altogether. And it's a virtuous cycle once you do that, right? Because the associated economic cost goes away, the health of the workers is improved, so you cut the danger out of its source. Instead, what I'm seeing is that you've got a regulatory and compensatory regime which is extremely deficient and lagging, and it may get to a point where once those things become more prosecutable and people's lives start to get an economic then there'll be cases brought, and we'll find ourselves 10, 20 years down the track with multi-billion-dollar losses in cases, and then there'll be a focus on why didn't we ban this at the start. I just wonder, and it sounds very callous to do this, but sometimes it seems the only way governments are convinced. Has there been any cost-benefit analysis or studies done on the likelihood of economic cost if we don't ban this substance now over a period of the next, say, 10 to 20 years? Or has anyone done that sort of economic analysis?
Look, I'm not sure of that, and I think that's an excellent idea. But just from, as I said before, I mean, I don't know who we're seeking to protect in terms of the commercial side of things with this. I mean, the importers come from, I think, Israel, Spain, Italy.
Mr. Cruz,
really dreadful stuff.
Mr. Cruz, if I could just interrupt you. I think your laptop speakers may be just a touch loud. If you could perhaps turn them down, because we are getting feedback when you're speaking now.
Yes, I will. Okay, hopefully that's better. As I said, the economically, all the profits from this are going overseas, and the joinery and installation work will continue. It just will be using different substances. As for the fabrication, they'll still be benchtop. They'll just be made from different substances. So I can't really see any real downsides on in terms of economic impacts. Banning the substance should really only improve the economic outcomes.
I'm just going to interrupt there. I know I've got two more questions from Mr. Diadam and Mr. Shoebridge. We've got very little time left. If we could, I know Mr. Diadam's on the camera. If you could ask a really quick question, seeking a really quick response, then I'll pass to Mr. Shoebridge.
Yeah, look, I just wanted to ask about the impact of HSRs in workplaces and whether you would support, particularly in the manufactured stone industry, a requirement for HSRs to be in place.
HSRs, I mean, any workplace that needs or wants HSRs can have those elections occurred in any event. I think mandating democratic processes like that, I haven't really thought that issue through. I think the problem with the installation time is that where a lot of the risks are occurring is in workplaces that are very, very small, just a handful, even less employees, where the ability for democratic processes like that to really have an impact isn't as great.
Thank you very much for that. Mr Diadam, HSRs for the benefit of Hansard.
Health and safety representatives.
Thank you. Mr Shibridge, one quick question before we close off.
Yeah, it's to both of you. From your experience of talking to members, particularly those who may potentially have claims or exposure, is there any explanation you can see for the significant reduction in workers presenting to iCare with silicosis claims? Because on iCare's numbers, the silicosis cases and silicosis-related cases went from 40 in 2018 and 2019 when we first started raising this issue, to 107 when we were forcing some screening in 2019-20, then down to just 37 in 2020-21, and then down to just 9 in 2021-22. Well, at least in the first 3 months of that. What, if anything, should we read from those numbers?
It's a really good question, and it's been on my mind too, Mr Shivich. I think the most explanation is that during the pandemic, there's been less opportunities for people to present for medical examinations generally. Everyone's been locked up in their homes. There's been less work performed in these dusty environments. So I think there's a very strong likelihood that these figures are anomalous. There's another matter that the physicians have brought up, which is a concern, and that is need to be taken to make sure that we screen properly. And we've had concerns where we've had to argue with employers who want to use chest x-rays for people coming out of tunnelling environments and where there's been silica exposure. The Western Australians have taken steps on this to pass a regulation to require CT scanning as the principal mechanism. And I know that the doctors raised some real concerns about the extent to which even though iCare say that people who report silica exposure are sent off for CT scans, iCare don't do all the screening. Some of it is done by employers. There needs to be steps to make sure that the screening is free, regardless of where the referral comes from, and the regulations need to be changed to make sure that for silica exposure, CT scanning is the method that's used, and employers can't opt for a cheaper X-ray, which is less effective in picking up the disease.
Thank you very much for all your apologies, Mr. Shibridge. We are out of time. I've got to stick to the time. Perhaps Mr. Donovan can provide an answer on notice.
On notice.
Yes.
In that regard.
Thank you for that, Mr. Donovan. And speaking of questions of notice, the committee has resolved that the answers to questions on notice will be returned within 21 days. The Secretariat will contact you in relation to the questions you have taken on notice. Apologies for the compressed time, but I thank you for your appearance today. We'll now switch over to the next witness. If we could admit them into the room, please. Ms. Flores, could I just do a quick audio check with you and confirm that you can hear me and that I can hear you?
Yes, I can hear you.
Thank you very much.
Can you hear me?
Yes, I've got you. I now welcome our next witness. Could you please state your name and position title and swear either an oath or affirmation? Ms. Flores.
Oh, I'm sorry. Yes, Natasha Flores. I'm the Industrial Officer in Work Health and Safety and Workers' Compensation at Unions New South Wales. I will swear an affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much, Ms. Flores. Could I ask you please to make a short opening statement?
Yes, and apologies for the cockatiel. This is quite short, so firstly I'd just like to thank the committee for the opportunity to appear at today's inquiry. Our concerns and Unions New South Wales concerns and the concerns of our affiliate remain the number of young healthy workers who are contracting diseases such as silicosis. These are diseases that we associate with the Dickensian era, and they did disappear for quite some time. In the 21st century, diseases like this should not be resurfacing. Safety control measures remain haphazard in the industry. We would like to see immediate government action that quickly eradicates such diseases and ensures that workers who choose to work in this industry or with building products that contain silica, and there are many of them, do not die 10 years into their career, which unfortunately is what we're seeing at the moment. So there are a number of building materials that contain silica. Most of them do. Silica is everywhere, but our major concern remains the artificial or, the stone bench tops, the manufactured stone bench tops. That's it for my mention.
Thank you, Ms Flores. And I'll now pass over to the committee for questions. Mr Diadam, I'll give you the call, and if you could indicate if you're asking Ms Flores or the cockatiel for a response.
Definitely, Ms Flores. Thank you for your appearance today. Look, I wanted to start by asking you about the Victorian licensing scheme that's been put in place for the manufactured stone industry. Is that something that we should be doing in New South Wales? Should we be emulating Victoria and putting in a comprehensive licensing scheme to regulate the manufactured stone industry?
We would agree with an approach similar to that, yes, absolutely. One of the problems that I guess when this first began to surface, which was probably when it had some media attention, I think around 2017, 2018, I think, there really wasn't a lot of regulation. I know SafeWork did do some work in the area, many visits, some advertising, but I think that needs to continue. Advertising certainly needs to continue, and there needs to be greater regulation of the industry.
The Australian Institute of Occupational Hygienists has described the silicosis epidemic as a product of the failure of the work health and safety system. Do you agree with that?
Yes. Work health safety is the prevention. Workers' comp, the dust diseases scheme, is a cure. Well, it's not really a cure. It's a fix-it, or we try to fix things, remedy things through the schemes that are available. But ideally, if we can avoid getting these diseases, we should. We encourage people to avoid other diseases. Don't smoke, don't get cancer, get checked regularly, get breast examinations, etc. Far better to get in there early and to get in before the damage is done. And from my understanding, these diseases are not curable. They are. They don't, unfortunately, give the person who has the disease a particularly long lifespan once they've discovered they have this disease. And it's very sad to see men in their late 20s, 30s dying because of the career that they've chosen, which is an important career and something that we need. Obviously, we can't get rid of stonework, masonry, etc. But we do have to control. We do have to put in much better control measures, and that comes down to our regulator and SafeWork.
Do you think specifically that the compliance approach that SafeWork has taken has led to the epidemic of silicosis?
SafeWork has taken an educative approach to much of what it's done over the last 5 or so, perhaps longer years. I'm an ex-teacher. I am not opposed to education. Education is extremely important. But I do believe that there comes a time where if education isn't working and people are dying, a stronger approach is needed. Prosecutions are needed, and companies need to be closed until they are able to guarantee that they can provide safe workplaces for their workers.
Do you think that, do you have perhaps any direct experience of safe work prosecuting in the manufactured stone industry? Are you aware of any prosecutions that have occurred?
As far as I know, there were many pins and notices that were when Safe Work did a bit of a back around 2019. I think they did a blitz, and that did result in a number of pins being distributed, warnings. I think one of the other problems in this industry is it's still somewhat hidden, so it's not necessarily easy for Safe Work or anyone to find these places. So, and what I've heard from affiliates is the problem may not be at the factory or it may not be at the warehouse. The problem may be when the manufactured stone arrives at the building site, whether that be a domestic site, a large block, a tower block in the city, when the bench tops don't quite match the measurements that were given to the workers, then unfortunately and I've been told often the only option is to cut that to the right measurement, and that happens unfortunately on site with dry cutting, which is, as we know, the most dangerous form of cutting this product, and it's happening in probably hundreds and hundreds of little renovations that are going on all over Sydney. I don't think there'd be too many kitchens these days that have been renovated that don't have this sort of engineered bench top. So it's very likely that dry cutting has occurred in many of these instances, and that's just really hard to find and to locate.
Do you think that highlights, I suppose, a resourcing question for Safe Work? Do you think there's an adequate, a number of inspectors, sufficient for the need, sufficient for the job in terms of compliance in this industry?
I've always said there probably aren't enough inspectors in the job. There are, I think, around 7,000, the last time I looked, and that was a while ago, businesses across New South Wales. We're a very large state. We are the business state, if you like, and there are a number of Safe Work inspectors who are classified as inspectors, but from my understanding, they don't actually go out and inspect. Their jobs are more desk-based administrative jobs. So I do not believe there would be enough. And in my fantasy world, you'd probably need 1,000 or so, and that's I think putting it conservatively, to get out there and to really service the entire state the way it needs to be serviced. And this is just one issue of many, many safety issues too. So, these inspectors are dealing with thousands of issues, very diverse range of issues every day. So I would not say there are enough.
Mr. Diadam, I'll come back to you if we've got time. Thank you. I'll ask Mr. Donnelly if he's got some questions. If not, I'll pass to Mr. Buttigieg, but I'll give Mr. Donnelly the option first.
Thank you, Chair.
Thank you, Mr. Donnelly.
Thank you. Ms. Flores, thank you for appearing today, and thanks to Units New South Wales for its submission. On page 6 of your submission, you, about halfway down the page, there's a paragraph and it continues on over to the next page.
Yep.
About the current minister, Mr. Andrews, sorry, Anson, I should say, and comments that he has made with respect to lowering exposure rates silica to a new lower rate of 0.02%, and other matters related to tackling the matter of silicosis. Are you able to provide us with any update or any reportage of bringing these things forward and making them happening, as opposed to announcing them and just talking about them? In other words, presumably Units New South Wales has been monitoring these announcements and making their own observations. Can you provide us with any report on what you're seeing happening?
I haven't seen anything happening. Now, I won't blame the Minister entirely. COVID has obviously been the priority, and that is understandable. We're in a national global crisis at the moment, so I do understand that is the government's priority. But I'm not aware of any movement or change since then. But that was towards the end of last year. We did break for Christmas. Many of us have just returned to work, so I would say that nothing has happened. I just am not aware of it at this stage.
Well, it's certainly not been publicly reported, as far as you know.
Not as far as I know. I haven't received any information.
Okay. Which perhaps has answered the question, which was to follow up, which is in the last paragraph on that page, about this monitoring of dust rates in tunnels and related industries. You've not heard any announcements about work being done in this area by Safe Work or anyone else?
No, other than, PR exercises about the tunnels, no. We actually approached Minister Keane a number of years ago with some disturbing photographs of the dust in one of the tunnels. I think it was North Connects, I think.
North Connects, yes.
North Connects. And
run through the electric.
Yeah, it was. You couldn't see a metre ahead of you, or beyond your hand if you put your arm out. And look, he was genuinely concerned. I have no doubt that he was genuinely concerned about the conditions, but that was a number of years ago. From what I hear, conditions waver. So you may have a very effective site manager who comes on site and says, right, this is going to be done, this is going to be done, and gets everything in place for the proper control of dust. But at other times, you may get a site manager on board who says, no, we don't need to worry about that, or perhaps there's some reason to rush on that particular day. There may be a deadline or something. So what we hear is that some days you've got good conditions, other days not so good conditions, and that all depends on A, the site manager, and B, the deadlines and the movement of work and how it's progressing. So, but the photos that I saw were certainly very disturbing, and that came from the Australian Workers Union, and they have had a number of their workers or members unfortunately pass away as a result of silicosis in the last couple of years. So it's quite sad that people are passing away who are young as a result of their job. An important job, but, very, very disturbing.
Well, on that very point, because it was my next question, that in looking at this area of silicosis, casting our eyes back and looking at the work done, it's quite properly come out of our enhanced understanding, particularly with respect to what's been going on in the manufactured stone industry and its manifestation with respect to particularly bench tops. In either the context of the large sites that do cutting, or the bespoke work that might be done by a person on site, for example, doing a home installation. But in the AWU's submission, in their recommendation number 1, and if I can just quote it, it says the current workplace health and safety crisis caused by silica dust is not limited, I repeat that, not limited to silicosis in the stone bench industry. Government responses must consider all industries where silica dust exposure is at risk, including but not limited to, and then mentions tunnelling, quarrying, cement work, mining and construction.
Yes.
I'd like you to comment on this, that there is now this very clear evidence that we are looking at something with a much larger remit as a problem beyond manufactured stone. It's an issue in a number of industries. Would you agree with that statement?
Absolutely, yes. I've read in some of the readings I've done, teachers who work in art departments with clay have one teacher in particular died. They often in schools reuse clay, so once kids have made their pots and figures and whatever they're making, they move on, and those pots and what have you get broken up into small pieces and then basically reused or recycled. So that's something I remember from my high school days. I was quite keen on art and pottery, so it's an area in even in people, artists who are making pots and teachers who are teaching pottery. So it's widespread, absolutely. I mean, bricks, everything, as I said, so silica is everywhere. It is part of the natural environment. It's in bricks. It's in the beach. It's at the beach. It's in all of our rocks. It is everywhere. It is a widespread issue, and it really comes down to figuring out what are the best control measures for the different situations, the different industries, ensuring that there's adequate training, and I would say educating the public in relation to the dangers, because there are a large proportion of these workers who would be from non-English speaking backgrounds, and they may not understand the dangers. They also may take on work that is not particularly safe because they want to keep their jobs. And that's actually an issue with a lot of the workers in this field. Speaking to these people, they don't want to lose their jobs. So it's a difficult situation, because doctors have also said that some of these workers don't want to know. If they don't know, then what they don't know can't hurt them, and if they don't know that they have a problem, then they can continue working. And obviously we all need to keep a roof over our head and food in our stomach. So that is
just my final question before I cede to another member. Just on the issue of what is mobile screening, you would be aware that there is a single bus that operates, that does mobile screening. Given that New South Wales, in terms of population and economy, is by far the largest in the Commonwealth, by far.
Yes.
You would agree with the statement that there's a good case that there should be additional funding set aside through the forthcoming budget for the funding of additional mobile screening in the state?
Absolutely, that would be wonderful, yes, because the buses go to the work site, so the workers are all going there together. So it's not a case of a worker going off by him or herself to the GP to hear the bad news. There is a certain amount of collective support, if you like, when the bus turns up and all the workers go into the bus to get tested. So that helps, and that gets people tested, which, as I said, can be difficult because people don't want to know. And the more we know, the more statistics we have, then the better able we are to deal with concerns, areas of concern, and able to identify particularly, we know stone bench tops are bad, but, what else is there that we don't know?
Thank you for that. I'll pass to Mr. Shoebridge now, then to Mr. Buttigieg.
Thanks, Chair. Thanks, Ms. Flores, for your attendance today. Have you reviewed the iCare submission?
Not yet.
Well, the iCare submission...
Sorry, I'm moving. My dad has cancer. I apologise.
That's okay.
No need to apologise, Ms Flores.
Sorry to hear about that.
That's okay.
It's genuinely. The iCare submission notes that the funding ratio for the dust disease scheme is only at 59%, and says there are they assert there's a number of reasons for that. Being higher than expected claims numbers, an increase in claims handling expenses, an allowance for remediating past underpayments and future payments. So, are you aware of those issues that the firm's been facing?
Yes, and look, we've always said that the worker should not bear the brunt of problems that have been created through perhaps iCare itself or mismanagement by the government.
Has iCare engaged with you and given an explanation about what their higher than expected claims handling expenses have arisen from?
We do engage quite regularly with iCare, myself and a number of my colleagues and employer representatives. And yes, there are many reasons, I guess you could say, as to why this is happening. New computer programs, etc. But, you know, it's often we come out of these meetings and there is an awful lot of spin and repetition.
We do. Have they engaged with your organisation in relation to remediating the past underpayments?
Yes.
Yeah. And are you satisfied with that remediation to date?
Look, given the time that it's taken, given the pain that people have endured, we are at this stage, we want the problem resolved and we want people to have that money in their pockets. So at this stage, yes, as long as people are able or workers are able to go back and, you know, dispute possible underpayments, which apparently they will be able to, then that's okay.
All right. In terms of that, iCare say that they have proposed to the government that the law be fixed.
Yes.
That nobody's payments are cut or their dependents refuse support based upon the date of injury.
Yes.
Has iCare approached you in that regard?
Yeah, we have met with iCare. Sherry, myself and Alan Mansfield, along with 3 employer representatives who've just recently changed, have had meetings with iCare.
All right, and has an explanation been given to you about why the government hasn't legislated to fix that?
No.
And I assume you would support the government rapidly fixing that?
Oh, yes.
And I'm assuming the Sherry you're referring to is Sherry Hayward.
Sherry Hayward, correct.
Yeah. All right, my final question is this. The scheme's finances seem to be in a mess.
Yes.
Much created by iCare itself.
Yes.
Failing to pay the proper rates in the past, now having to meet them in a lump sum and not properly putting in place provisions for those future payments, as well as this mysterious term of increased claims handling expenses, which seems to be just iCare getting bigger and bigger.
Yeah, that's what we've heard, yes.
So, what do you see as the pathway to fixing up the deficit in those circumstances?
Look, if I had an answer, I'd probably be a very wealthy woman, not sitting where I am now. But let me just say that part of what I do is I run a committee of other union affiliates who work in this space, and these are constant conversations that we have. So any proposals that we have, ideas that we have, we are able to, and overall to, you know, iCare's credit, we are able to bring those to iCare, and they do listen. They don't always do what we'd like them to do, but they're listening, and compared to 3 years ago, that is an improvement. So in this business, I'm not used to changes very rapidly, but given that, these are people's lives we're talking about, we do need pretty rapid changes in this area. But we do have some concerns. We've heard that the POE calculations have been offshored, and we just have no idea why on earth an organisation would offshore something like that, because that could, surely it can't create less expense. Surely it slows the process down. It's got to create more expense. So things like that, which we don't necessarily know about, they often just come out accidentally in the course of our conversations. So,
well, Ms. Forrest, can I just thank you for your engagement today and your ongoing engagement in this space, and I again just express my regards and concerns in relation to your family matters. And
I'm sorry.
No, and I genuinely appreciate you coming here today with your experience and understanding.
Thank you so much, and thanks for the understanding. It's part of life. Thank you.
Thank you, Mr. Shibridge. I'll now pass to Mr. Buttigieg for a few questions, and then I'll pass to Mr. Martin.
Thank you, Chair. Ms. Flores, I just want to take you to some evidence we heard from a couple of your affiliates this morning in the CFMU and the AWU, and it goes to this whole concept of there's a bit of a dichotomy, I guess, conflicting outcomes between eliminating the substance altogether, and the logic is that you're cutting material into very fine, almost atomic granular particles which can't be detected. Therefore, the only way to really tackle this thing is to get it out of the input to the economy for a start, which Mr. Cruz advocated was the way to go, because it's largely an import industry where importers are obviously gaining big windfalls and all the rest of it. Vis-a-vis obviously there's the regulatory and the compensatory approach to deal with the issue as it stands now. I just want to get your view on whether or not, because, I suppose the more we fix the system to deal with what we've got now, the less emphasis there will be on banning the product. So I just want to get your views on where you stand on that particular issue.
And look, there are different views because we're talking about people's jobs here. Sorry, am I echoing?
Oh, no, it's not too bad.
I was about to say, Mr. Buttigieg, I think it might be you that needs to mute, and that might stop the echo. Maybe now, Ms. Flores.
Okay. There are some differing views due to the fact that these are jobs that we're talking about, people's jobs, and obviously unions don't want to see people lose jobs. We want people working, and we want people working in good work. As I've said, silica is a product that is everywhere. It is very high concentrations in the manufactured stone, and I would love to see some innovation and some work done in Australia because, we're not stupid people. We have, I think, the capacity to look at other substances, look at other products. And let's be honest, this is a fashionable item. This is something that is in fashion at the moment. It hasn't always been in fashion, and it may not always be in fashion. But I would love to see, and I know there is some work being done out there, some really innovative companies doing some work to produce items that can be used as bench tops in kitchens, bathrooms, etc., that are not as deadly. There's still a lot we don't know from my reading about and my discussions with the Thoracic Society. there's a lot that we don't fully understand about the manufactured stone, and it may not simply be the high content of silica. It could also be a combination of the resins and other products that are in there and how they interact together. So my view would be we should be putting money into businesses who want to investigate, design, look at products that are going to perform a similar task that will be equally beautiful and fashionable, but hopefully not as deadly. There are, I know that there are some organisations or some of these, and I live near one actually who is probably one of the gold standard companies that they don't manufacture the product, but they do sell all sorts of, stoneware, marble, manufactured stone, etc. And the reason I've done this is because I am moving and I'm looking at my own kitchen. They do all of their cutting in a particular room. Nobody is allowed in that room. The room's completely sealed, etc. That doesn't necessarily mean, though, that fibres aren't going to end up on the floor. That was one of the first things that alerted people to this problem. Tradies' dogs were dying because they'd spend their day on the floor of the factory breathing this product in. So that was one of our first indicators that there was a problem. So whilst at this stage I'm not going to say let's ban the product altogether, I would really like to see the government put some money into encouraging businesses to look to other products and to consider what else we could use. And as I said, it's fashionable. It's fashionable now. It wasn't fashionable 20 years ago. It may not be fashionable in 10 years' time. So, wooden bench tops may be back in. Marble, I'm seeing, is being used quite a lot, which is still not, entirely safe. It has a much lower content of silica. So, so we are talking about something that is a fashion item, essentially. So when you put it like that, you think, oh, well, surely that's not worth dying for. And surely fashions come and go. Surely we can find something else that will do the job and look just as great.
Okay, thank you. Just one more quick one, because has Taylor got enough time, Chair?
If you're very quick, Mr. Buttigieg, we'll be fine.
Just quickly, Natasha, I take you to page 8 on your submission, and Unions New South Wales strongly supports recommendation 49 of the McDougall review.
Yes.
Which is the responsible minister for Safe Work New South Wales, which is Anderson, I think.
Yes.
Conduct a public review of that agency's performance with regulatory and educational functions under the WFS Act 2011. The implication of that paragraph is that the Act itself has got enough provisions in it that if it's properly enforced and implemented, we could go a long way to ameliorating some of these concerns. Is that the implication to take out of it, or do we need to change the Act as well to give it more teeth?
Look, it would probably be something that would need to be placed within the Act or have another written. I personally would like to see some sort of oversight similar to the oversight that happens in the workers' comp system. So, you have an annual review. You get to, like myself and anybody who's interested, are able to write a submission, appear at an inquiry. I think that sort of independent oversight is really important in any sort of organisation, So the fact that Safe Work doesn't really have it, I think, is lacking. It's a problem, and I think it would be a great remedy to have an oversight, some sort of committee such as this that does an annual review, and there may well be or after COVID, or once we go back and we look at pandemic and we just sort of trying to figure out what work on better. That may be one of the outcomes from that. Sorry.
Mr. Buttigieg, I might ask you to hit mute on your computer because I can hear the feedback again. Mr. Martin, you now got the call.
Thank you, Chair, and thank you for your time here today, Ms. Flores. Have you got any feedback on the user experience from any of your members who have used the Lung Bus or the Pitt Street Clinic?
No, I don't. That's probably a better question for my colleagues because we don't deal directly with members. We deal with unions who have that direct dealing with members.
Sure, of course.
But look, the doctors that, well, I've been in touch with the Thoracic Society. They are very keen to see more of those buses, although they will also explain why in some of the buses need to have higher levels of technology. That's certainly not my area. I'm not an X-ray specialist or a thoracic specialist, but my discussions with the society suggest that yes, more buses would be great, and the buses also need to have the capacity to do one other sort of test, which I can't remember at this stage. I'm sorry.
That's okay. We'll take it up with them later on in the day. I'll pick that up. So just going back a second, your involvement with the affiliate unions, are you aware of any of the unions pushing any education campaign in this regard, either to its members directly in the field?
As far as I know, the AWU have been running a fair bit of, I don't know if you'd call it a campaign, but certainly information to their members in relation to tunnelling is their particular area because that's where their members are working. I know that the CFMEU does have meetings with members and they do discuss this because their concern is not so much their members actually cutting this product, but their members are on site, often on building sites, when this product is being cut. So their members are not cutting the product, but they are exposed, I guess a little bit like secondary smoke. You know, they're working in a building and they then also breathe in this silica dust.
So just following on in regards to the exposure on the side, and much of your submission does talk about reducing the exposure limit, lowering that exposure limit.
Yes.
Or the exposure rate, rather. Out of curiosity, do you have any idea how exactly that's measured or monitored on site or in a factory setting?
So, look, it's not an easy thing to do, but I do know that, and through SafeWorks, Work Health Safety Research Centre, work is happening in this area. So the work that's happening is around a very cheap device that a worker would be able to wear individually, and that would sort of clip onto the worker's shirt or whatever, and that device would be able to provide a reading. So there is work happening in this space, and it's certainly a right business opportunity for anyone who's interested in or has the capacity to do this. And I think that, you know, again, any government assistance that could be given to any organisation that has the capacity to do this work would be, I would say, would be money very well spent, because workers can then identify themselves, okay, this area that I'm in is a high-risk area, we need to do something, get out of this space and fix it up.
All righty. Thank you. That's all from me, and thank you again for your time today.
Thank you very much for that. We've pretty much reached the end of our session today. So, Ms. Flores, for the questions that have been taken on notice, the committee secretariat will be in contact with you to organise a tabling of them, and that's within 21 days. We're now about to take a short break. We'll be returning here at 11:30 with the next session. Well, welcome back to the next session. I'll now ask our next two witnesses to provide their name and position and title and swear either an oath or affirmation. I'll start with Ms. Cole.
Thank you. Kate Cole.
Thank you, Ms. Cole. Your position and swearing either an oath or affirmation.
Sorry, I can just hear your feedback, but I'll ignore it. So, Kate Cole, President, Australian Institute of Occupational Hygienists. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much, Ms. Cole. And did you say you're getting feedback through the system?
Yes, I can hear myself on repeat and you on repeat about 5 seconds after you've spoken.
Roger that. We will see what we can do if there's anything on our end. Mr. Shearer.
Yes, my name is Michael Shearer and I represent the Mine Ventilation Society of Australia as the current president. And I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you very much, Mr. Shearer. And what we might do is we'll just reverse the order for opening statements. So, Mr. Shearer, if you might like to start with an opening statement, and then we will see if we can do anything about Ms. Cole's connection.
Okay. So, as I mentioned, my name is Michael Shearer and I represent the Mine Vent Society of Australia. The society was founded 10 years ago in 2012 by a group of mine ventilation practitioners such as myself. Our members all share common passion, dedication and commitment to ensuring a safe and healthy work environment is designed and implemented for fellow workers in industries such as mining, tunnelling and associated work groups. Albeit there is no current legislation that supports the Stone Bench Group, potential risk of exposure to airborne substances is an important issue in other industries as well and certainly needs to be addressed through regulatory support. Our vision is to help provide evidence to provide industry and regulatory bodies with the understanding, advice, best practices and practical management controls to lower and mitigate potential risk of personal exposure to any harmful airborne substances that are in the workplace. The strength of our membership and industry partners provides access to decades of knowledge and experience from both local and international individuals and groups. This partnership, through sharing, enables collaboration to create practical and functional solutions. The MVSA has previously provided feedback and review of related guidelines, codes of practice and training to other regulatory bodies and industry groups to further improve practices and understand practical solutions. Industry needs to be supported by regulatory changes with an alignment of current best practices and a commitment for improvement. The introduction of statutory appointments with competently trained ventilation practitioners and certified occupational hygienists will help ensure that industry is supported with the knowledge, skills and experience that is required to keep workers safe and maintain a healthy workplace environment. Thank you for your time.
Thank you very much, Mr. Shearer. And Ms. Cole, we'll now try and see if we've got any improvement there. If you wouldn't mind making your opening statement. Thank you.
Thank you very much. I would first like to acknowledge the traditional owners of the land that we're meeting on today and to pay my respects to elders past, present and emerging. I'm here to represent the Australian Institute of Occupational Hygienists as their president. We're the largest organisation representing professionals in this field in this country. I've worked across many industries where silica dust exposure occurs and where the resulting debilitating silica-related diseases unfortunately still exist. I'm a Winston Churchill Fellow on this very topic. As occupational hygienists, we are the ones who assess the risk of exposure. We're the ones who measure silica dust and verify if the measures in place are enough to keep workers safe. We remain concerned that the true magnitude of silica-related diseases in this state is underrepresented, and the experience of our members and information that's been provided to us is that the level of compliance with existing work health and safety legislation in the main remains low. So low, in fact, that very few companies are completing air monitoring for silica dust. It's been reported to us that when Safe Work New South Wales undertook inspections during 2020 and 2021, they found that only 15% of businesses in engineered stone had some form of personal air monitoring report. At these inquiries, there is always a focus around the workplace exposure standard, but a number on a piece of paper does not prevent silicosis, and indeed, that number is worthless if air monitoring is not undertaken and if actions are not taken as a result. This is not just an issue in engineered stone, but indeed across other industries, highlighted most recently with 42% or almost half of cases of silicosis reported to June 30, 2021, being from industries outside of engineered stone. So our concern extends to workers in construction, quarrying, demolition and tunnelling, for example. We are also concerned that despite the improvements made since the 2019 review, that significant work still remains to protect New South Wales workers from silicon-related diseases. The key improvements that we see as necessary include 1, a registration or licensing scheme that includes air monitoring and provision of those results to our regulator. Air monitoring is the primary key leading indicator to the development of disease, and yet it's not being used to inform compliance strategies as best it could. Secondly, our view is that we need stronger regulation to get rid of the grey areas that still exist that enable workers to get sick. And 3, increased enforcement of work health and safety regulations, which at a minimum means undertaking inspections across high-risk workplaces. I note that during the period between 2020 and 2021, it was reported to us that Safe Work New South Wales were only able to undertake an inspection across less than 60% of engineered stone businesses. And finally, we need improvements to requirements around education, training, health monitoring and labelling information. Thank you for the invitation to be here this morning, and I'm very happy to take any questions that you may have.
Thank you very much, Ms Cole, and thank you for your opening statement. For those opening statements, if they were pre-prepared, if you wouldn't mind just emailing them through to the Secretariat so that we could pass them to Hansard, it helps them with their transcription. I'll now pass to the Honourable Anthony D'Adam to open the questioning.
Thank you, Chair, and thank you both for your attendance today. I might start with you, Ms Cole. What is a safe exposure standard for RCS? You're on mute.
It's important to understand that a workplace exposure standard is not a fine dividing limit of what is safe or unsafe. It's what can be complied with, it's what's measurable, and it's what actually results in safer workplaces and a lower prevalence of disease. And to refer back to my opening statement, if we don't have workplaces that are measuring compliance to that workplace exposure standard, that number is useless.
Accept that, Ms Cole, but surely we have to set the level somewhere in order for compliance to occur. It should be set at a safe level. What should be that safe level?
Just before I ask Ms Cole to answer that, Mr D'Adam, RCS for the benefit of Hansard.
Respirable crystalline silica.
Thank you.
So the current workplace exposure standard, as you know, is 0.05 milligrams per cubic metre, which is a level that can be measured. And I note the many other inquiries and task forces that have recommended a reduction of that exposure standard to 0.2 milligrams per cubic metre. I will note that a significant body of work needs to be done to enable the accurate measurement and sufficient certainty when measuring respirable crystalline silica at that level. So if you reduce the workplace exposure standard, you start to have issues with regards to enforcement of that and how accurate that number is. The lower you get to the level of detection, the higher amount of uncertainty that you have. And in our experience, exposures to workers of respirable crystalline silica are well above the existing workplace exposure standard, and in fact, in some industries, orders of magnitude above the workplace exposure standard.
But the experts are saying 0.02, aren't they? That's the safe level that the sort of emerging consensus in terms of exposure.
So I guess back to my previous points, it's important that whatever level is set, that it can actually be measured. So I support the reduction of the lower. Absolutely support the reduction of lowering the workplace exposure standard to 0.02 and the necessary work that needs to be done to get to that point. Absolutely. But even at 0.02 milligrams per cubic metre, I don't want to give the committee the view that it automatically defines a workplace as automatically safe or unsafe. These are upper limits. We have to reduce exposure so far as reasonably practicable, which in all cases means below that workplace exposure standard.
I just want to take the opportunity.
There's no
Sorry, I just wanted to
safe level.
Sorry, I'm doing now what I just wanted to remind just all committee members and witnesses, it's obviously hard for Hansard to transcribe if we're both talking over each other. So it's best to wait just a short pause after you've finished answering, just to allow any lag before the next question. Thank you, Mr. Dowden. You've got the call.
Sorry, so I was going to say that obviously if there is no safe level, there is an alternative. If we can't measure at a safe level, then the alternative is banning the product, surely.
So we support a ban of manufactured stone. Absolutely. It's a high-risk product. We've seen that the level of compliance in the engineered stone sector is incredibly low. Yes, we support a ban of it, but please understand that banning manufactured or engineered stone does not solve the problem of silicosis in this state. High quartz is ubiquitous. It's in construction, demolition, tunnelling, in sectors that don't even handle that type of product. So, yes, banning it is one solution, but it's not the bigger picture.
Can I ask about, so you're supportive of a stronger enforcement regime. You'd be familiar with the measures that have been introduced in Victoria. Can I ask, does the Victorian system in their engineered stone control plans require air monitoring?
Not to my knowledge. So with regards to what we're calling for in terms of a licensing or registration scheme, we need to add the provision of air monitoring to our regulator, because that's the best leading indicator we have. Whilst counting how many workers have silicosis helps us understand the issues that have happened historically, this is actually helping us understand what may happen in the future and helps, I guess, hone regulatory efforts to the highest risk areas. There's a limited number of inspectors granted, so we need to make sure that their efforts they need to make sure that their efforts are best placed on the highest risk workplaces, and the only way they can really do that is through provision of standardised information to help inform their decision making of where their efforts are best spent.
Okay, thank you. I might turn to another committee member now.
Thank you, Mr. Dowden. Mr. Buttigieg, you got the call.
Thank you, Chair. Look, feel free for any of you to answer this, but I've probably following on from some of my colleagues' questions, Ms. Cole, in terms of if there's a consensus emerging that it's 0.02, and I'm sort of looking for an analogy, I guess, with the way we've dealt with mesothelioma asbestosis. In that particular pernicious part of the industry, have we determined, I suppose is the question, what an unsafe level of microns is for inhaling asbestos? And could you give us an analogy of where with the silicosis industry? In other words, if I think what I picked up before from what you said is 0.02 is not necessarily a safe amount either. Therefore, if you lower it, which there seems to be a consensus that we should, it doesn't necessarily mean that 0.01 won't be a hazard as well. Is it different with asbestos in that we have determined what a safe level is or not?
Look, the workplace exposure standards relate to comparing measurements that we take to a compliance number. Again, they're the highest level that shall not be exceeded. And the duty of care is to reduce exposure so far as reasonably practicable. There are some similarities with regards to silicosis and asbestos-related diseases, but there are also some differences if I just outline some of them. So at the moment,
Sorry, Ms. Cole. Mr. Buttigieg, would you mind just muting your microphone again? Ms. Cole, if you could just restart your answer, apologies. We do get some feedback when Mr. Buttigieg hasn't muted.
No problem. Just reiterating, the workplace exposure standard is the highest level not to be exceeded, and the duty is on the employer to reduce exposure so far as reasonably practicable. What I mean by that is even if the exposure standard is 0.05 milligrams per cubic metre for silica dust, which it is, it doesn't mean that just because you measure a sample at 0.04 that you don't have to do anything. If there's reasonable measures that can be put in place, i.e. ventilation, engineering controls or respiratory protection, then they need to be put in place to lower exposure so far as reasonably practicable. But to the question around asbestos-related diseases and silica-related diseases and air monitoring, a licensed asbestos assessor, if they go to a workplace and they measure asbestos in air above a certain limit, they're required to report that to Safe Work New South Wales. If an occupational hygienist does air monitoring in tunnelling or an engineered stone, for example, and they return a result well above the workplace exposure standard, that result doesn't go anywhere except the employer. Arguably, the employer has a duty to inform their workers, but that result doesn't go to Safe Work New South Wales, just like it does for asbestos.
Can I interrupt you at that juncture, because I think that's a very important point you're trying to make. Leaving aside the thresholds, and I'm presuming you'd agree with the logic that if you do reduce it to 0.02, then there's likely to be a more, like it'll trigger more testing and reporting below those levels, which would in theory make it safer. But leaving that aside, what you're saying is that the analogy of the asbestos industry is interesting, because if a hygienist does an air quality check in a tunnel, for example, and they return a result that's above the acceptable standard, 0.05 currently, then they're not required to report it, whereas if it was asbestos, they are. Is that correct?
Correct.
So that would be, in your view, that would be a key legislative reform at the moment. If we could compel those employers to report above that level, mandatory, that would be a significant reform, wouldn't it?
It would be a significant reform, and it's the step change, the type of step change that's needed in this state to actually reduce the cases of silicosis.
Have you got any commentary as to why that obvious sort of levelling with the asbestos standards hasn't been transmuted across to the silicosis industry? Can you offer any commentary as to why that's the case?
I think that's a question best posed to our regulator. I don't have insight as to why.
Okay. If you have anything else to add to the previous answer, continue. I just thought it was important for me to tease some of that out.
Well, I'll just maybe add to the previous questions around the safe level and 0.05 and 0.02. As permitted concentrations become lower, determining compliance becomes more difficult. So it requires increasingly accurate and precise field and laboratory measurements. And I referred to a paper that was commissioned by Safe Work Australia on this very topic, which outlined a series of recommendations of actions that needed to be done in order to measure accurately to that level. And that came to the Australian Institute of Occupational Hygienists, and we supported all of those recommendations. I'm not privy to divulge the contents of the report because I don't have it in front of me at the moment, but just to say that worker health protection is paramount to us, but how you get there is ensuring that our regulator can successfully enforce existing regulations and employers comply with low exposure standards. And unfortunately, the case seems that that's not happening at the moment.
So, Ms. Cole, can I just a couple of follow-ups on that? There's that, in theory, if we were to go down to 0.02, it's not possible to measure that currently, is it, without significant extra investment, is my understanding?
Without significant work, not accurately.
Okay. Just one more, again, using the asbestos industry as a as an analogy, the air quality monitoring, what is the current requirement for an employer to carry out air quality monitoring in a silica exposed environment at the moment? Is there a trigger that mandates when that has to be done?
It relates to Regulation 49 and 50 of our Work Health and Safety Regulation, which I don't have exactly in front of me, but to the effect that if they're unsure that the workplace exposure standard will be exceeded or if there is a risk to health. Unfortunately, we don't have prescriptive requirements, but we have seen other states start to develop those prescriptive requirements around air monitoring, and we need that type of prescription in New South Wales. So not just how frequent that air monitoring is done, but by which profession. Because we're talking about accuracy. It's not as simple as grabbing some pumps and putting it on a worker and getting a result. This is why at the Australian Institute of Occupational Hygienists, we have very robust membership and certification schemes, such that when employers are engaging certified occupational hygienists, they have confidence that such air monitoring will be done with appropriate standardised methods and the level of quality that's needed to get that accurate result. It's the type of thing we need enshrined into our regulation.
So, Ms. Cole, that prescription that you're advocating, which I think is another important point, at the moment it's too open to interpretation. There's too much latitude for employers not to do the air quality testing. Is that the same? That applies in the asbestos industry, or is it more prescriptive in that space?
The asbestos industry is far more prescriptive, to the point that the person that does the air monitoring must be a licensed asbestos assessor. In business that removes asbestos must be a licensed asbestos removalist. There's licensing schemes there. There's standardised practices, there's codes of practices that relate to that industry. And when you look for the same for silicosis and silica dust exposure prevention, it's very lacking.
Okay, thank you. So in sum, when we're legislating this sort of thing and looking to reform the Act, we could learn a lot from what we've done in the asbestos space, in other words.
We could definitely learn a lot, but I'd also say to the committee that we in this state could learn a lot from the work that's been done in Victoria with regards to their improved regulation and also their licensing scheme, in addition to Queensland and their code of practice. So I think there's a lot that can be learned nationally for the benefit and improved outcomes for workers in this state.
Yeah, that's coming through strongly in other evidence. Thank you,
Mr. Buttigieg. I might just ask you to mute again if you wouldn't mind. We are getting a lot of feedback through your system itself. Mr. Shearer, I'm going to ask you, if you wouldn't mind, just to speak about your submission to the committee and provide us some insights about, I guess, the way that I read it. It is looking at the elimination hierarchy of the risks around dust diseases through the elimination, engineering, risk assessment type model. Could you expand a little bit on that, please, and just provide us some insights as to your experience?
Yes, so level of experience, been in the mining and tunneling industry for almost 20 years. It's been my observations and learnings throughout that time that industry really needs support through regulatory guidelines, codes of practice, but also one thing, by lowering the exposure standards doesn't really take care of the other side of things, where you can have all of these limits, but if you don't support the industry through training, codes of practice or guidelines to help those industries understand what their obligations are and how they can get people that are certified, whether that be occupational hygienists or ventilation practitioners who are competently trained, then we're really just leaving a hole in the wall that, as you said, leaves things for interpretation. So the industry needs that support from the regulatory bodies, or industry moving forward. So The controls that were mentioned in our submission, they're first obviously being elimination or substitution, being that depending on what industry you're speaking of, specifically for the stone masonry, some of those materials can't be modified or substituted. So if controls are in place and people understand their obligations and there's competent people out there that can help support the industry, then that way I see an opportunity to help those industries to lower their exposure limits or like exposures to their workforce by understanding and being better educated.
Thank you for that.
What now?
Thank you for that. I was just going to ask, are you aware of any, say, engineering advancements that may have been made in this space between when we held our last set of hearings and now that might provide some assistance to the committee around not only the monitoring, I guess, but also the filtering or the removal of the dust particles in a number of settings, not only, I guess, the factory workspace, but also the job site, the installation site itself, which is obviously where, wet cutting, in a factory is easier, but it's a much harder thing to do on site.
Well, as I previously mentioned, it's that consultation with the employers to understand what the tasks that they're undertaking, whether that be on site, in a factory setting, out in the open, and understanding what controls are required for that specific task. Mm-hmm. It's not a one-size-fits-all, I guess, is the easiest way to say it. So in that way, through that consultation process and understanding what the task is, where it's located, you could actually engineer or relocate the task to another position. I previously mentioned in the another hearing was that there's advancements in technology with inbuilt filters on handheld equipment, but it all goes with the magnitude of the actual location, the task, and that's putting together not only stone masonry sector, but also other sectors, whether that be mining, etc.
Thank you for those valuable insights, Mr. Shearer. Oh, sorry, I'm just mindful that there's probably a number of committee members who might have questions. So I'm just going to see if there are any government members who might wish to seek the call. If not, I know Mr. Buttigieg has indicated he might have some more, and perhaps Mr. Diadam. Oh, Mr. Buttigieg, you got the call.
Thank you, Chair. Mr. Shearer, I found that point you made interesting, and the hierarchy of controls, which is, I think it's elimination, substitution, PPE, or something of that order. The point is that elimination is the preferred, but the elimination is not always possible. So I guess one example would be in manufactured stone. It's quite, I think, easy to mount an argument to say that if the end product is to make people feel good when they walk into their kitchens, but at the manufacturing end, we're exposing people's lives, then there's an argument, I guess, to eliminate the product, particularly if you can substitute it for something else. Whereas if you're boring a tunnel under the harbour through sandstone, it's a bit hard to eliminate the product. So can you just give us a feel for what stage the things like mine ventilation and that sort of technology is up to in terms of getting rid of the hazard that workers are exposed to, and maybe just a little bit of an outline on where this product ends up? Like, presumably if you're ventilating microscopic dust, it's got to go somewhere, and where does it go to keep everyone safe? Sorry, that's a few questions there.
That's right. So I'll go back to what I mentioned previously, in that if you identify what the substance is the process and how you intend to eliminate it or manage it. So generally you would have the source, where the work's being, so I'm not being specific here about any industry, but you're performing a task, that task produces whatever the substance is, or that may become liberated during that process, and having the correct controls, whether that be by wet cutting or extraction type systems where that material is then pulled through a filter system that might be able to filter 99.99% of those solid materials out of the air. And then those solid materials are then collected and then eliminated or removed and then processed or delivered to another point where they're then handled, and whether that be turned into a type of sludge. The point that I'm making is that those materials are captured through the filter process. They're then processed or managed or handled or contained so that then they're not re-liberated into the airspace in that work area. As far as what happens after that, those materials may be able to be reused. So you go down that whole recycling pathway. There's a lot of other alternatives, but getting back to the main point is this is where both consultation with ventilation practitioners and also occupational hygienists is through that consultation process. I feel that there could be opportunity for some sort of licensing type thing where it goes through levels of or layers where to get a license to operate, the entity needs to have others such as occupational hygienists or ventilation professionals in order to sign off to say that, yep, these are the controls and this is how we're going to be compliant. Otherwise, as was mentioned earlier, it just leaves things to open to interpretation, and everyone may interpret things in their own way.
Can I just follow up to that, Mr. Shearer? Can I just use the sort of analogy framework I did with Ms. Cole before in terms of the way that works with the removal or the cutting of asbestos? Is that regime of industry being consulted, the right ventilation people being brought in, all those controls much more elaborate in the asbestos space than it is with silica?
Well, in the asbestos space, I would take that question, to come back on notice. Yep. I can't give you a straight up answer at this moment.
I thought you might have been involved in your industry in ventilation for asbestos too, but that I totally understand if that's not something you've experienced. So.
Yep, not personally. I have other members within our group that do. I'll refer back to them.
Right, thank you.
Mr. Buttigieg, I was just going to say I might pass to Mr. Diadam if you wouldn't mind, and I might just, we're getting a little bit more feedback if that's okay. Thank you.
I just wanted to come back to some comments that Ms. Cole had made earlier in response to the questions from Mr. Buttigieg. I wonder if on notice you could provide the specific regulatory requirement around asbestos notification that applies. I'm just looking at the Regulation 50 that you cited, and obviously there's nothing, as you said, there's nothing there that requires a business to provide those results to the regulator. So I notice if you could provide that. I wanted to further ask you about the technology for air monitoring and whether it has a capacity for real-time reporting, or whether that's not currently something that's capable of being done.
So Thank you for the question. The first part, I'm more than happy to, that level of prescription is contained in our codes, and Safe Work New South Wales would probably be best to answer that, but I'm more than happy to provide a very brief overview on behalf of the Institute. The second part of your question related to air monitoring and real-time air monitoring. From an occupational hygienist perspective, we welcome the introduction of new methods to test for silica dust in air, and we note the great work of the Centre for Work Health and Safety and the development of their real-time silica in air monitor through company Trolex. But I just wanted to explain maybe the detail of that just for a moment. It's actually not personal exposure monitoring. It's not a device that you put on a worker. That was the original intent, but I understand through development that that device is actually quite maybe briefcase size or maybe a little bit bigger, and is something that you would say plug into a mains power or a generator, and isn't overly portable, so it's a fixed static device. It's still great, but it's not personal exposure monitoring that goes around with a worker. And whilst it's also not, unfortunately, overly affordable, although I will note the great work in terms of rebates that are available for businesses to adopt it. From memory, the unit is being sold at a cost of approximately $20,000. So that's not going to be amenable for all businesses. And I note that 80% of businesses in the engineered stone sector are less than 10 workers. So these are very small micro businesses. Notwithstanding, it is a great step in the right direction. But to my previous point, engineered stone and indeed other sectors where silica dust is a risk have a relatively low level of compliance with the workplace exposure standard, or indeed regulations more broadly. So real-time monitoring, or in fact any monitoring, is only going to be successful if there's a requirement to use it, and if there's a requirement to report that data, or there's a requirement to do something when you get a result at a certain level. So whilst we welcome it, we also remain concerned that it's not the be-all and end-all solution to the problem that we're currently facing.
But there is a requirement, isn't there, Ms. Cole, in Regulation 50 that you pointed to, that they are required if there's a substance that requires to be monitored, then they are required to conduct that monitoring if they're using that substance.
Yes, you're right, but that does not relate to real-time monitoring, and actually it can't, because that regulation only applies to personal exposure monitoring. So that means that the monitor is affixed within the worker's breathing zone. The worker is carrying that monitor, and it's measuring the amount of silica dust that worker is being exposed to over the period of their shift. That's very different to a box that's sitting in a work site measuring the ambient concentration of silica dust. Notwithstanding, personal exposure monitoring is not difficult to do when the right professionals such as occupational hygienists are doing it, but in the experience of our members, we hear a lot of the time that engineered stone companies call them to ask for a quote to do air monitoring, and when they hear how much it is, they don't engage. Because as I said before, they're very small businesses, money is tight, this all costs money. So unless there's a real push to make them, through a licensing or registration scheme, do this, what we've seen in the past 2 years is that the uptake is relatively low.
But if a business can't afford to conduct its business in a safe way, should it be able to continue to operate?
No, they shouldn't be allowed to continue to operate, but unfortunately that's not the current situation we have in the state.
And so in terms of the current practices around e-monitoring, you're saying that this is conducted on a sort of sporadic basis, or, you know, over a sampling system? Like, how is it actually conducted now if it's not done in real time?
So an occupational hygienist would attend the worksite in the morning. They would understand what the workers are doing. They would affix pumps onto a series of workers. This may be 10, 12 pumps, for example, which measure or collect silica dust in the air. That pump stays on the worker all day, and the occupational hygienist is observing all the different control measures in place to keep them safe at the same time. The pump is then collected, the filter is taken out of the sample cyclone, the sampling head, and it's sent to a NADA accredited laboratory where the analysis is undertaken. The occupational hygienist gets that result, compares it together with the information from the pump, so how much volume of air is being collected, comes out with a number. And that number is compared to the workplace exposure standard. So the time between doing the monitoring and getting the result can be typically about 2 to 3 weeks. So in the case of engineered stone, that may not be such a big deal because it's the same work happening all the time, but it's a real challenge in construction and demolition when the work activities change all the time. So when you get a result back, it's representative of work that happened 2 or 3 weeks ago. And not necessarily the work that happened today, which is why monitoring is done more frequently in construction and demolition than it is in businesses where it's the same process repeated over and over again.
Thank you. That's all I've got, Chair.
Thank you very much. Just noting the time, I might thank the 2 witnesses that we've had appearing today and remind them that for questions that they've taken on notice, the Secretariat will be in contact with you within, very shortly to table your answers within 21 days. We will now take a very brief break while we transfer witnesses, and we'll commence the next session in about 4 minutes.
Thank you for your time.
Thank you.
Yeah, thank you.
I now welcome our next witness. If you, Mr. Jennings, could please state your full name and position title and swear either the oath or affirmation.
Yes, my name is Martin Jennings and I'm a consultant occupational hygienist.
Thank you. And this is the oath or affirmation. Thank you.
I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you very much, Mr. Jennings. I'd like to invite you to make a short opening statement, please.
All right, well, thank you very much for allowing me to appear before you and present my evidence. My evidence is largely based on workshop visits and from providing evidence as an expert witness in several compensation claims, and more recently as an expert assisting the prosecution in WorkSafe Tasmania. This happened in November. That's particularly relevant to my first recommendation. I'm pleased that the New South Wales Government is maintaining its strong focus on the artificial stone industry. As I've detailed on page 4 of my submission, there are a number of features about this particular industry that are unique. It's also relevant to note that artificial stone is a substance under the Work Health and Safety Act. This means that manufacturers, importers and suppliers all have a duty of care to make sure that the product can be used without risks to health and safety persons. Now, this has largely been interpreted as meaning providing labels, safety data sheets, and more recently, fabrication manuals. These are basic legal obligations. But if you want to look at their effectiveness, I'll just ask you to consider the chemicals in your own garden shed or at home, for example. You know, before you take a shower in the morning, do you read the label on the shampoo bottle? when you're using pesticides or paints or solvents or adhesives? Do you read the product label? Would you think to get a safety data sheet? Or would you do a risk assessment? Now, my guess is probably not. But if when you're buying the product from Bunnings, the store assistant said, no, you can't use these with ordinary rubber gloves. You're going to need PVC gloves to use this product. You'd take a bit more notice then. You'd listen and you'd follow their direction. Now that is the nub of what I mean by product stewardship, and this is going to be a large essence to my submission. That's covered in page 16 of the submission. It's something I believe has been lacking to date. Now, also on page 16, you'll see a statement from a stonemason who was interviewed on the TV programme The Project. He said they've been working for 20 years as stonemasons. They started using natural stone, and nobody ever told them about artificial stone being so different. Now, you've got to remember, natural stone, something like marble, has a silica content of 2 to 3%. Artificial stone has a silica content of 90 to 95%. Huge difference. I've also sent you 3 newspaper translations from Spain, dated around 2010, as a supplementary submission. These report on 6 cases of silicosis in a workforce of 11 in Guernica. The regulator, the Spanish regulator, took the manufacturers to court for failing to provide adequate information or instruction. I also report on page 19 of my submission that Caesarstone reported to the US Securities Commission that they were aware of silicosis cases in Israel going back to 2008. So my question is, I don't know if you recall seeing this timeline in the Golder and Associates report to the New South Wales Safe Work Commission. It shows that it was 2010 when usage really took off in Australia. So had these companies then issued a global alert saying, hey, we're getting all these cases of silica associated with our product, then I believe these stone companies in Australia would have sat up and taken notice. The regulators would have been enforcing the regulations, and the health department would have been suitably positioned to look at cases coming forward. So we didn't know until 2015, until the first case was diagnosed. And this was then followed by hundreds of other cases, and all this, I believe, could have been easily avoided in 2010. Despite this, the information is still inconsistent, it's often patchy, and it's often at odds depending from which company you get the information from. And I discuss those issues on page 16 of my submission as well. So for this reason, I particularly want to focus on recommendation 4. This is the duty of the manufacturers, importers and suppliers, and I believe that they should have been held accountable for this failure to exercise their duty of care. And I also believe on recommendation 6 that the industry should consider a product stewardship scheme. They tried to implement a fabricator accreditation scheme with the ACCC a couple of years ago, and this was rejected. The reason for this being rejected was comment to the effect that they were abrogating their responsibilities as manufacturers. So I'm happy to leave my statement there, and I'm happy to take any questions now. Thank you.
Thank you very much, Mr. Jennings. And just in relation to the sheet that you held up earlier, could I just get you to identify a little bit more that sheet, just for the benefit of Hansard, but also the Secretariat?
Yes, I'm sorry. It's a report that was published by Golder and Associates, and it's a case finding study into respirable crystalline silica exposure in the New South Wales manufactured stone industry, and it was dated 17th of May 2021.
Thank you very much, Mr. Jennings.
Attachment to the Safe Work submission.
Thank you. I just didn't catch it in time and wanted to make sure that Hansard could actually reference it in the report. Mr. Jennings, if that opening statement was pre-prepared, would you mind emailing it to the Secretariat so that we can provide a copy to Hansard for the transcription?
Happy to do that. Yes.
Thank you very much. Mr. Diadam, would you like to start the questioning?
Well, thank you, Chair, and thank you, Mr. Jennings, for your appearance today and for your submission. I want to go to this idea of the stewardship scheme. You're correct in terms of the account of the arrangement with the ACCC and the manufacturers being unsuccessful in getting that scheme off the ground. We've seen in Victoria, though, the introduction of a licensing scheme that incorporates the importers as well as the fabricators. Do you think that is an adequate alternative, some kind of comprehensive licensing scheme that follows the full supply chain?
I think, yes, that goes some of the way, but one thing I would like to stress is I think this should be done across the whole of industry. What you're seeing now is some material that's been published by some suppliers is quite good, but in other cases it's very poor. Now, if I'm a fabricator and I'm looking at two safety data sheets, for example, from two separate suppliers, one tells me I can use a P1 or P2 respirator, the other one tells me I need a supplied air respirator. Well, you know, that's expensive, so I'm going to go with the P1 or the P2. So there needs to be a more consistent information that's been provided. And
is that something that the regulatory bodies could enforce on the suppliers?
I believe so. I believe that there is a code of practice for the preparation of material safety data sheets, and this could address some of the other issues, such as information being provided that isn't always relevant to Australia. It's written around EU legislation, or in some cases it references American OSHA legislation. So it needs to be, in some cases, more specific to the Australian work environment.
The importers have, in their submission, suggested that they want a national regulatory scheme in place. Obviously, this is a state-based inquiry and we're looking at the regulatory regime that exists in New South Wales. What is your view about whether New South Wales should follow Victoria's lead and step into the space and put in place its own regulatory regime, or should we wait until there's movement or some consensus at a federal level?
Well, I've made reference to the Commonwealth Product Stewardship Act. This is, it tends to focus on the environmental impacts of health and safety of a product. But I don't see why conditions couldn't be added to those, to the accreditation of a product under the Product Stewardship Act. And the Minister, as I put in my notes, the Commonwealth Environment Minister can add artificial stone to a priority list of product stewardship accreditation.
You're very critical in your submission of the Safe Work and its regulatory approach. Would you like to offer some further comments in relation to that?
Yes, and I think this is largely based on comments such as those I put in my submission from the stonemasons, who say nobody ever told them that this was such a hazardous product. And I worked in the chemical industry when hazardous chemicals regulations were introduced in 1990, in the 90s. Then the emphasis was on, you've got to go to the very start of the information chain. The manufacturer knows what's in his product, he knows how it should be handled, so it's his responsibility to make sure that every stage in the chain is adequately informed. And if they are not, then they can't exercise their own duty of care. And I should add that when working as a WorkSafe inspector with WorkSafe in WA, I actually took a prosecution on that basis of a supplier, in this case of hairdressing products. The manufacturer didn't provide any information, which meant that all these salons were incapable of handling the product properly.
And do you believe that Safe Work, it's open to Safe Work to prosecute on that basis, the importers?
Oh yes, it's Section 23 of the Work Health and Safety Act. The duties on the manufacturers, then there's separate duties on the importers and separate duties on the suppliers. They're fairly similar. And being the duty of care, it doesn't actually specify that we're talking about labels, safety data sheets or manuals. My experience of, and if you allow me a couple of minutes to explain this, if you recall going back to the 1980s, the Bhopal incident, where Union Carbide killed thousands of people with a leak from their plant with a product called isocyanate. This was a lethal compound. In the 90s, I visited ICI Americas to look at their product stewardship scheme for handling isocyanates. The way this worked was when you bought the product from ICI, you didn't just get the product, you got the services of their product steward as well. So he would come in, inspect your premises, tell you what you needed to do to handle it properly. When you purchased it, he would come in through the gate with the product. He would arrange air monitoring, health surveillance, check that your ventilation systems were adequate. Right to the very end of the product life cycle, when you were disposing of it, he'd make sure it was disposed of in a responsible manner. And that was a tremendous asset to the company in America, because as you know, they're so conscious of the impact of litigation there. The users of the product were very happy to have that assistance from ICI. So that, to me, was product stewardship in its best form, best practice.
Do you mind if I jump in there?
Yeah, sure, jump in.
Mr. Jennings, are you aware of any manufactured stone companies that actually engage in anything similar to what you just described?
No, I have seen some very good materials that are now being produced, but I think the onus is still on the fabricator to apply those and do the testing that's required, the fit testing for respiratory practice. And you'll also notice in my submission, I've drawn attention to a picture on, I think, page 17 of a respirator being worn on a safety data sheet cover. Now, that's not the right sort of respirator. That's a P2, and it won't give you adequate protection. It'll give you a protection factor of 10, perhaps, if it's worn properly. You may not be able to see it, but this particular individual is quite hairy. So he's not going to be able to wear his respirator properly. Small companies, and we're talking, just a few employees, don't have the resources to do this sort of level of testing, the air testing, the health surveillance. They're required to by law, but I think this is where the manufacturers or the suppliers should be stepping in and adding this as a sort of a value-added product to their stone.
Mr. Martin, have you got any further follow-ups? I think that was an indication.
Sorry, just off the back of.
I might just jump back in then. I just wanted to ask one further question. I mean, obviously, this is a dangerous product. We've heard evidence around the workplace exposure standards, the incapacity to measure at a safe level and therefore be reasonably assured that workers are operating in a safe environment, should we ban the product?
Look, if you do that, then we already know that products like, I can't remember which firm in particular, is already manufacturing in countries like Vietnam and China. And all I think would happen is that the production would simply be shipped offshore if it was to be banned here. If you were to ban the import or control it through the, I think it's the prohibited imports regulations, the customs prohibited imports regulations, you might be able to control it that way, as we do with asbestos already. But it can be handled safely, but at the moment, we're still a long way from getting to that stage.
Okay, thank you. I'll hand over to the Chair.
Thank you, Mr. Diadam. Mr. Buttigieg, have you got some questions that you'd like to ask?
Look, maybe just to follow up, Mr. Jennings, on that point that my colleague asked about. I mean, if you've got a substance, and I keep using this asbestos analogy because, you know, we've sort of learnt a lot of lessons, I guess, or we should have learnt a lot of lessons from that substance. If you've got a substance like that which is embedded in the built environment, as it has been in Sydney and throughout Australia and other countries, and you then put controls on the import and use of that as a result of 50, 60 years experience of people gaining respiratory diseases, mesothelioma, dying, then wouldn't the logic transfer across to a substance which has actually got a much quicker time frame in terms of contraction and then potential death? And understanding that it's not there's an opportunity now to cut this off at the mark before it becomes too entrenched. I mean, and we touched on this before, there will be certain environments where you just can't do that because it's in the natural environment, as in, you know, sandstone and all the rest. But in that manufactured stone space, that engineered stone, where the exposure and the risk seems to be extremely much higher, then is that something that you would consider to be best practice in terms of engineering out the problem in terms of like a ban?
Yes.
Second part, let me just touch on, Mr. Jennings, sorry, you just made the point that it can be safely handled, presumably with the right technology and PPE and all the rest of it. So I just want you to try and reconcile those two sort of things for me.
Okay, I might start by making the point you touched on the sort of time frame and the fact that, you know, it's been around in other buildings, in other infrastructure for many years. What makes engineered stone, artificial stone, so different is the time frame between initial exposure and onset of illness. Now, this means young people, I think the youngest has been 22, have been contracting silicosis. Now, this means it's easier now to prosecute companies under the Work Health and Safety Act because you can establish the elements for the prosecution. A, that the duty of care was owed. 2, that there was a breach of the duty of care. And 3, that because of that breach, the illness occurred. Because you can show that, you know, young Joe was working at this company all his work life before he got this disease. He couldn't have got it anywhere else. So that's always been difficult to prove in the past. And it can now even fall within the period of the statutes of limitations. So that's one thing. As for a safe workplace, now this seems to all hinge on using controls like wet machining, grinding, polishing, or using CNC, computer numerical controlled equipment. So it can be all housed within an enclosure, it's suitably wet, and that keeps the dust levels down to an acceptable level. Now, having said that, you've got to remember that I visited workplaces and they think they're best practice, but they only wear respirators, for example, for the duration of a job, if they're grinding or polishing. And then after 5 or 10 minutes, when they finish, they'll take it off and move on to the next thing. And I particularly want to show you the diagram on page 5 of my submission. This shows you how long it takes dust particles to settle in still air. So the respirable size particles, the smallest ones, which are less than half a micron in size, can remain airborne for over 40 hours. So this means that people can come to work on a Wednesday morning and they're still inhaling dust that was raised on the Monday afternoon. Now, if you've got wet processes, you can capture most of that dust. But otherwise, I think people are over-reliant on personal protective equipment, and this is why you've got to look at higher order controls like engineering systems, machinery, wetting, rather than relying on respirators.
We've only got a few minutes left. I want to give Mr. Martin the opportunity to continue his line of questioning, if that's okay. Mr. Martin, you have the call.
I just want to pick up on that last question in regards to the comparison to the use of asbestos, because it does come up and it's the obvious thing you think of when you first get your head around this issue. Is it a fair comparison in your opinion? I mean, is there a safe way of working with this material, knowing that the risk is in the cutting and polishing of the product, and it's very obvious where this product is used, whereas with asbestos, I mean, throughout housing, it's used in cladding, it's used in insulation, it's used in a million things, including brake pads on cars. So I guess, is it a fair comparison? And I say that as the grandson of someone who worked for James Hardie and died with asbestos in his lungs. So I'm not saying it to discredit it. I genuinely want your opinion here.
Yeah, look, there are a lot of similarities, and people have even referred to this as being the new asbestos. The big difference, though, is asbestos typically mastocytosis doesn't manifest until several years after exposure. This time frame is much more compressed. So this is, and I think I say somewhere in my submission, this is unlike anything I've ever seen in 40 years of practice. So, and it's much more, once the onset of disease has started, it then seems to ramp off very quickly. The other thing, of course, about asbestos is it's often found in people's homes, old 5-row houses, and if the dad's a handyman and he sort of potters around the house doing odd jobs, then often people who lived in that house as children will start to develop the condition when they're adults. So you can't always sort out the occupational versus the domestic exposure with some of these cases.
No, I guess that's why I draw your attention to whether the comparison is fair or not, because there's plenty of stories in my family alone of what you just said there, of people back in the day cutting it up themselves and being exposed decades later secondhand. But let's be frank, no one's really cutting a kitchen benchtop or polishing it at home in a dry way. So I guess the heart of my question is, are there procedures that near on eliminate this risk? So whether it's that there's so much misting and water available that, and PPE, of course, and that the cutting is done in a factory environment rather than on the work site or something of the sort. I guess the question is, are you able to minimise this to near zero?
Yes. And you've made a very interesting point there, one which was raised at the last review in 2019 about the factory environment. The point was made when, particularly on the Gold Coast, which is where a lot of the cases seem to come from, if you're building a 30, 40, 50 tower block, story tower block, and someone has to take a sheet of manufactured stone up to a kitchen that's been fitted there, and if the holes don't quite align with the taps or the sinkhole is out of kilter, you're not going to take it all the way back down to the factory. You're going to do it on the work spot. Now, this shouldn't happen, but it does. You know, the culture in these small businesses is they don't have the time to take half a day out of their work schedule to do that sort of thing. So they'll fix it on the spot. And of course, being in an apartment that's been fitted out, they don't have the luxury of using wet processes either.
Yeah.
So, yeah, you've got to the nub of a very important issue there.
Yeah. Works in theory, doesn't work in practice.
Mm.
All right. Well, thank you, Mr. Jennings.
Well, that pretty much brings us to the end of this session today. Mr. Jennings, I just wanted to say thank you very much for appearing, and any questions that you've taken on notice, the Secretariat will be in contact with you for you to be able to table those within 21 days. We'll now be taking a lunch break and we'll be returning at 13:45. Thank you, everyone. Well, welcome back to the afternoon session for today's hearing, and I'd like to welcome our next set of witnesses. If I could ask Dr. Edwards to state his full name and position title and swear either an oath or affirmation, that would be great.
Thank you. Dr. Graham Edwards. I'm a senior consultant physician in occupational environmental medicine, practicing in Queensland. I'm the former member of the National Dust Disease Task Force by appointment of the Honourable Minister Greg Hunt, and I am representative of the Royal Australasian College of Physicians, appearing today as a member of the Australasian Faculty of Occupational Environmental Medicine. I'll take an oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you very much, Dr. Edwards. Associate Professor Yates, if you could provide your name, full name, and then position, title, and swear either the oath or affirmation.
Yes, certainly. My name is Deborah Yates, and I am a respiratory physician with qualifications in occupational medicine as well.
Sorry, Professor Yates, do you mind, Mr. Buttigieg, could you mute your microphone, please? If you could just start again, please, Professor Yates.
Yep, certainly. Thank you. My name is Deborah Helen Yates. I'm a thoracic physician, and I have qualifications in respiratory medicine, also in occupational environmental medicine. I am a conjoint associate professor at University of New South Wales and senior staff specialist at St Vincent's Public Hospital in Sydney. I'm currently appearing as the RACP representative for respiratory and general medicine, and I'm also a board member of the Thoracic Society of Australia and New Zealand and the spokesperson for Occupational Environmental Lung Disease, and also on the Lung Foundation Australia Occupational Environmental representative, although I am appearing in this capacity only for RACP.
Thank you.
I would like to take an oath.
Thank you. If you could take that now, that'd be wonderful. Thank you. Do you have the card with you?
I do. Do you want me to start or for Graham to start?
I believe Dr. Edwards has already done his. Yes, yeah. If you could just take the oath now, that would be wonderful.
Yes. I swear that the evidence now given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you very much. And Associate Professor Yates, just while we've got you on the active screen, I might just ask you to do a short opening statement if you've got one, and then I'll pass back to Dr. Edwards.
Yes, certainly. I would like to thank the Standing Committee for asking us once more to present our evidence. As you know, the Royal Australasian College of Physicians is very concerned by the recurrence of silicosis, and we have all been very much involved in trying to assist with this over the last 3 years or so. As you know, we have a number of issues that we particularly would like to urge the committee to consider. The first I know you're all aware of is the fact that we would like to implement a free and a comprehensive case-finding program as a matter of real urgency. We appreciate that the New South Wales government has actually already been involving eye care in this particular strategy, but we would like to highlight the fact that we have first-hand experience of certain difficulties with this, including the fact it's rather a clunky system for the individuals involved, and we don't feel it really conforms to the categorisation of a fast-track compensation system such as has been implemented in other states. We also, again, on the first hand, have found that there is really very limited funding available for retraining and vocational support for a lot of those workers who have been affected. And this is a real problem. It also has definite psychological effects on them because they find that they are often young and they have a young family to support and they have real financial difficulties, let alone the anxieties that have been generated by a diagnosis of an essentially incurable lung disease. So we feel that that is something which the committee could perhaps consider to highlight as a priority, which is of great importance. A lot of these people have been really left, what they regard as totally unsupported, and they are also in a situation where they are unable to find other employment. And so this would be something which they would very much require. A third issue is the fact that we still find that there is a lot of difficulty with regard to obtaining information from the New South Wales government with regard to the actual data on the number of cases of silicosis that have been occurring, and in particular the number of cases that are really exposed within the artificial stone industry, because we appreciate the fact that we've been told that Safeguard Australia knows who these all are, but we don't have any information of exactly which employers these are. And when a patient comes to see us and says that they're actually employed by some particular person, we have no idea whether there's anybody who's, this is a workplace which has been assessed at all, nor do we have any information about the dust levels. And we actually would like very much to be able to feed back and actually complete the loop and make sure that that optimal dust control is actually implemented very early on. We also don't have any information on the number of cases on the amount of manufactured stone which is actually imported into Australia, whether this is going up, whether it's going down, or exactly how the regulation of this is progressing. And we also need return to work data about the number of cases of diagnosed cases, types of retraining that's been provided. All of these issues are hopefully relatively easy to actually progress, but we need maximum transparency. And I have to say that having presented to this committee on a couple of occasions in the past, it's really a little bit disheartening not to have seen further progress in New South Wales. We have had, I think, comparably, compared to other states, New South Wales is lagging behind. And we in the college would very much like to encourage better dissemination of information, better case finding in particular, and better control of this really often lethal hazard. Thank you.
Thank you very much. Dr. Edwards, would you like to make a short opening statement now?
Thank you. And to complement what Professor Yates has indicated, we greatly appreciate the work of the Standing Committee and the recommendations that you have provided the Government of New South Wales in the past. Likewise, I express on behalf of the College our deep concern and that the overall progress has been less than what we feel is both recommended and needed to protect the health and well-being of workers of New South Wales. In looking at the Golder Associates case finding study from May 2021, it indicates to me that there is a material underestimate of the magnitude of the problem in New South Wales. It is detecting the more severe end of the spectrum of disease, not the minor end of the disease, or what is better characterised as the early stages of the spectrum of dust-related disease, which I remind the committee, the dust-related diseases are latent diseases. They are reflecting a cumulative exposure to the hazard over time. And as a consequence, we wish to identify these people at the earliest opportunity, not wait till they're actually getting to the point where they're having to present to the hospitals, where they're having to line up for the lung transplants, when they're having to be made disabled and unemployable and no longer able to engage in productive activity in support of the well-being of themselves or their family. The earliest detection of these people is fundamental if we're going to maintain their quality of life and engagement and support of the people of New South Wales. So the National Dust Disease Task Force has released its findings in its final report from July last year and highlighted that for any worker in the engineered stone sector that was working prior to September 2018, 1 in 4 people had evidence of disease. That is significantly greater than the low prevalence being purported to be present in New South Wales. The data is evident that New South Wales is under-detecting the magnitude of the problem. There is no evidence from our perspective as clinicians seeing these people that you are in the processes and systems of dust disease scheme in New South Wales, picking up those people at the earliest possible point to be able to intervene effectively. One of the other attributes that we were significantly disheartened to read was that the recommendation 8 of the committee from your 2017 recommendations has been not supported by the government. What we have found through the efforts of the National Dust Disease Task Force and our colleagues in both Queensland and Victoria, that when you're relying on compliance checking and an aftermath of exposure and identifying those people who are breaching safe work practices, it is too late. The people have already been exposed. And consequently, the Victorian government has piloted a licensing scheme, and the task force has recommended that Safe Work Australia develop a licensing scheme for the model laws. And I would encourage this committee and your recommendations to the government of the day to reconsider and implement a scheme that enables that only those people who can demonstrate compliance with safe work practices are able to purchase and fabricate with the engineered stone product. And so there is a significant need for further research in the area to prevent and manage and treat silicosis in particular. But what I also remind the committee is that it is not just silicosis. The dust diseases extends across a spectrum of diseases, including lung cancer.
Thank you, Dr. Edwards. We'll now move to questions. I'll start with the Honourable Anthony D'Adam, and then I'll move to Mr. Greg Donnelly.
Thank you, Chair, and thank you, Dr. Edwards and Professor Yates, for your attendance today, and thank you for the college's submission. I wanted to first come to the issue that Dr. Edwards just touched on, the need to introduce a comprehensive licensing scheme. I mean, this is an urgent problem, isn't it? Is this something that we should wait for a national licensing scheme, or do you think it's appropriate for New South Wales to follow Victoria's lead and introduce a licensing scheme in New South Wales?
Thank you, sir. It's not a matter of New South Wales following. It's a matter of New South Wales taking the action that is necessary for New South Wales. There is absolutely no doubt that in order to establish a national licensing position, we need guidance in the model laws. But if New South Wales waits until those model laws are developed by Safe Work Australia, then New South Wales will need to look at the governance and administrative processes of implementing those within the New South Wales jurisdiction. So there is a lot of work that can be done now without waiting. And I can also encourage the New South Wales agencies to be actively involved in the process of developing the practical guidance we can learn from what is happening in Victoria at the moment. We can learn from what we are seeing at the pointy end in those dusty environments. And one of my concerns is that with the major construction companies who can directly import the product into their on-site fabricating premises, they are not going through the same supply lines as, for instance, Hsrs Stone or any of the other major manufacturers who are importing into Australia and then distributing to their customer base. The major construction companies are directly importing to their sites and then fabricating on those construction sites. And as a consequence, Safe Work New South Wales may well be missing the ability to find these locations, and we are seeing the consequences in the non-compliance with safe work practices.
Dr. Edwards, do you have a view about whether a licensing scheme should extend to the individual workers? So individual workers who are handling manufactured stone would require a licence as well? Or do you think that it's sufficient for the employers, subcontractors and those other entities up the distribution chain, that it would be sufficient for the licensing scheme just to apply to them?
One of the advantages that we have is we do not have any manufacturing of the engineered stone in the Australian marketplace. So we've got a point of detection and point of control of the product coming into landing on our shores. So the border control strategies can identify to Safe Work New South Wales or the appropriate regulatory agency the landing of the product on the shores in New South Wales, which then enables you to follow the product through. I suspect that with adequate licensing and policing of those licences and ensuring that the PCBUs are complying to the licence requirements, the need to drill down to the level of the individual worker will be not required. At the end of the day, it comes down to a worker doing the best job they can under the circumstances they find themselves. If they're under the pressure of performance to take the shortcuts, to not put on the PPE, to not use the wet processes, and to not to disassemble a bench top that needs to be trimmed slightly.
Dr. Edwards, we just have lost your... Sorry, we just lost your audio then. If you could just repeat your last couple of sentences.
Sorry, can you hear me again?
We've got you now.
Okay. So what I was saying is that if the individual is having to comply with safe work practices of their employer, then that's what they will do. It's only when the individual is taking a shortcut under performance pressures that we see the material breaches. What we found when we surveyed the workforce at the National Task Force level was that they basically want to do the right thing, but it's the circumstances created by the business environment and by the economics of the moment that dictate whether or not they can.
Mr. Diadam,
there might be some advantages in terms of having a comprehensive screening process, worker education, that a licensing scheme that extends down to the worker level would have some benefits, though.
Yeah,
Dr. Edwards, I'm sorry, we've lost your audio just again.
Sorry.
Still a bit croaky.
It's cutting in and out. I'm not too sure if it's a pickup issue. Might be a voice-activated issue. Are you perhaps using are they Apple, like AirPod Maxes? I think the battery may be slightly flat in them, perhaps. We've lost you again. I'm sorry, Dr. Edwards.
Perhaps, if Dr. Edwards can, if the transcript it doesn't properly reflect his comments, he can perhaps take that question on notice and provide some written response if
that might be a
appropriate reflection of his comments.
Yes. What I'll do is I'll pass to Mr. Donnelly, and while Mr. Donnelly's asking his question, Dr. Edwards, if you could just perhaps look at maybe disconnect the headphones and then go just to your regular audio system on your computer. Mr. Donnelly, you've got the call.
Thank you, Chair. My question is to both the Doctor and Associate Professor, but in light of the current situation, this may need to be taken on notice by Doctor. But it's this point that when we, as a committee, first started to look at this matter some years ago now, we were primarily concentrating on matters associated with the silicosis arising from the manufactured stone industry. And that has been our primary focus to this point. We now, though, have become aware through evidence that this matter goes beyond the boundaries of that specific industry and, in fact, is an issue in a number of industries. And without being exclusive of others, the ones that have been mentioned specifically are tunnelling, quarrying, cement work, mining and construction. My question is this. We now have this before us, these other industries, which will naturally draw our attention. But I had this great fear that by our attention moving to these other industries, when in fact we still have not made the progress we want in the initial industry which drew our attention to this, it almost potentially becomes an excuse for the slowing down of dealing with some of the regulatory arrangements that are being proposed on the basis that, listen, this is something that's very broad. So I'm just wondering your thoughts about how do we keep the pressure right on to deal with the very specifics that we've identified, which is, dare I say, the pointy end of the problem, namely manufactured stone. But whilst we're dealing with that, raise the boats with the rising tide in the other industries.
Do you want me to respond to that? Or Graham, do you want to?
Thank you, Professor Yates. That might be a good start.
Okay.
Thank you, Professor.
Thank you. I totally appreciate the problem. I think it's very important to actually obtain transparency on engineered stone and get engineered stone really sorted out properly first, because we haven't achieved as much as we'd hoped over the last couple of years. The next step then logically would be to extend to all exposures to silica within every environment, using the methods which have been documented to work for engineered stone. This would be something which would be relatively easy to do in a regulatory fashion. And I have to say, this is not a new problem. This is something which has been known about for many years. And I personally, as a physician, can't quite appreciate why it's so difficult to implement these systems which are protective of people's lives, and that includes the licensing system. And I think one of the important things is to make sure that there's a portability for the individual worker, because people move, they move from one job to the next.
Yep.
When one has an appropriate surveillance scheme for everybody associated who is exposed to silica, then you will pick up the other diseases. But actually the appropriate surveillance, which if it's done properly, will pick up those other diseases, and that will give appropriate time for the learning that has been applied to engineer stone to be applied more widely. I agree this is a really, really important point, and I think that this is something which we need to move quite fast on. We in the college would be very happy to assist in any way that we can, and similarly, I mean, we can talk to other jurisdictions, not necessarily only within Australia, but throughout the world, as part of the Global Silicosis Consortium, which has been established by respiratory physicians. So I think this is something which is key and which needs to be moved on rapidly.
And I take note you've emphasised the word rapidly. One final question before I pass on to my colleagues. Associate Professor, obviously to tackle this, money and resources are needed, and to tackle it concurrently on a number of fronts. But I'd like to actually specifically ask you a question around the importance and the prioritisation of testing, and how we are going about doing that in New South Wales, and the arguments about why this is, as one of the fronts we're tackling, one that needs to be significantly boosted in terms of its deployment of resources, and noting, of course, that the industry is diverse from the very large manufacturing sites through to, you know, boutique individual jobs being done on units or residences and everything in between, and of course, obviously, right across the state. So how do we move as rapidly as we can and most effectively enhance the testing element of all of this?
I think we have to introduce totally free systems which involve CT scanning and lung function, which is not ordered by the employer but done from the worker. It needs to go from the worker up, because these people are disempowered. They are very keen to get this done, but they don't want to have it reported to their employer. They don't want to have it potentially mean that they lose their jobs. They want to make sure that they can take care of their family and get early treatment, but they're scared at the moment. If, for example, Safe Work were funded appropriately to implement a scheme such as occurred in Victoria, where they have a very rapid clinic with a fast-track system and dedicated staff who have established procedures, they have an appropriate clinical guideline pathway, and they have free access for all, without an upfront cost and without a cost in particular to the worker, that would actually enable these people to come through. Although that would potentially enable people who haven't had much silica exposure to apply, in general, the workers they don't want to apply unless they really have an issue, and that would be safer in the long run to actually enable them to come. I mean, you know, we struggle to provide free services or, you know, Medicare billed services in the public hospitals, but that is getting much more difficult, and it's really a great struggle to do that. But this is the way to save money in the long run. It's not going to be half as expensive as having many people who are very sick for a very long time cared for through a variety of different ways of doing that.
Sorry,
I think
Professor.
To take a leaf out of other people's books and go down that pathway.
Associate Professor.
I just wanted to note that we've only got about 15 minutes left, and so I know I've got a number of members who want to ask some questions. So Mr Shoebridge will get the call first, then Mr Buttigieg, and then I'll give the government an opportunity to ask questions if they'd like. If we could keep perhaps the answers succinct as well as the questions, it'd be helpful for everybody. Mr Shoebridge.
Thanks, Chair, and doctors, thanks both for your ongoing engagement in this space. I'm sorry we haven't stepped up and managed to get Parliament to go where I know you, particularly Dr. Yates, have been urging us to get Parliament to go for 4 or 5 years. But what do we want? Gradual change? When do we want it? In course. But this is now urgent. You say, Dr. Yates, that actually getting this right at the front end is critical to saving the finances of the scheme going forward. Are you aware that the scheme is only 59% funded at the moment and is actually, in fact, facing an $833 million deficit? And one of the reasons, apart from mishandling of claims, one of the reasons is they've got a surge of future claims, partly through silicosis. Were you aware of that?
No.
Yeah, but can you give an idea? Sorry, Dr. Graham, you go.
Yeah, I can certainly comment that the same scenario is happening in other jurisdictions where the insurers are having to assess how they're going to fund their future liability. So that also gives you a key to how to fund the future liability, and through avenues that require industry specifically to contribute to their insurance premiums appropriate to their risk profile. Now, I understand that it is being explored in a number of different jurisdictions as to how that might work, but it's to complement the shortfall in funding that has been evident.
If the manufactured stone industry, for example, is allowed to continue to function, and I personally am persuaded by the evidence we had from the construction union this morning that a ban is the best solution, but if the manufactured stone is still allowed to continue to operate, well, that industry should be hit with an insurance premium that covers the costs and the risks. Is that your position, Dr. Graham?
It is indeed.
Dr. Yates?
Definitely. I should add that Caesarstone has known all about this since at least the early 2000s. And you know, these companies are making extremely large amounts of money.
And all those profits are offshore, Dr. Yates. They're all offshore in large offshore manufacturers.
Exactly, but they have to import it into Australia.
Are you aware whether or not Caesarstone and those other importers have managed to get insurance cover? They were having difficulty getting insurance cover 2 years ago. Have you seen any reporting from them or otherwise about their insurance cover?
No, Graham?
I'm unable to comment. Well, I can say, though, that if you drill down to the cost of the product, if you add another $600, $700, $800 to the cost of the product, it makes very little difference to the market reception to it. It's already in that gap between the high-end natural stone bench tops and the other alternative. So the additional cost per unit of in-store product will not make any real difference to the market, but it can fund the needs of the industry.
Yeah, but the better solution, rather than pay for future damage, is to avoid future damage, and that's why you put forward licensing and a whole series of more rigorous approaches, including tracking down the stone that's been directly imported by construction companies. That's one of the big missing gaps at the moment, isn't it?
Mr. Shidrich, I concur that if the industry cannot be made compliant, fundamentally, I do acknowledge that the product can be fabricated safely. It can be. But what we don't have is a system of fabrication that enables that to happen in a reliable and robust and ongoing basis.
Dr. Yates? Sorry, Dr. Graham, we're so short of time. But,
sorry.
Did you complete it, Dr. Graham?
I'm happy to pass the baton.
Cool. Dr. Yates, do you think the industry is able to be safely regulated? Does experience to date suggest that?
I have my reservations. I'm afraid I do not believe that the industry is notorious for its compliance with regulations. I think that the workers are on the whole encouraged to do things that are not safe, and they're very they're uneducated about it as well. So I, as you know, I think a ban would be better. I think there are other products that are available which are very nice, like Australian wood. I see no reason why people should be dying for a totally unnecessary reason. Just one and that is that, you know, we in the healthcare will be bearing the costs of this. And, you know, the costs of long-term care for these patients is actually very significant. And ideally, these would be borne by the industry that has actually caused them.
Can you give an indication of the ongoing treatment costs, say, for a lung transplant and then ongoing treatment costs for the years that follow a lung transplant, Dr.
Mr. Shoebridge, could I ask you, sorry, could I just, Mr. Shoebridge, is it possible you might be able to put that question on notice? I just wanted to give some other members the opportunity, and I know Mr. Buttigieg's waiting, plus the government, so...
Well, we've already had extensive questioning from Labor, from two MPs. Is this going to be a third Labor?
I'm...
1.5 million for transplant, probably about 800,000 at least for ongoing care after every 5 years.
All right, thanks, Dr. Yates. So that's well over $2 million that is paid for by the health system as a result of the damage caused by manufactured stone when there's a lung transplant. I did have a question about the artificial intelligence being used on X-rays and whether that's a good or a bad thing, given, as I understand it, your firm position is CT scans should be used.
I might ask you, Mr. Shoebridge, are you putting that question on notice, or is that...
So to come into action properly.
Sorry.
All right. Well, I'll put that on notice and we might get a more clearer answer on notice. Thanks.
Thank you, Mr. Shoebridge. Mr. Buttigieg, you've got a very short window to make a couple of questions to the witnesses.
Thank you, Chair. Look, this is for either of you or both to respond. I just want to get a feeling for the time frame, I guess, of the from diagnosis to, I guess, terminal result. I mean, with asbestos, of course, there's this view, I think, that it takes such a long time, and sometimes that might attenuate people's view of the seriousness of it, because it really only becomes a problem in old age. Sweeping generalisation, obviously. But could you just give us an idea of the contrast with the onset of this sort of disease?
Depends on the dose. So with the artificial stone exposures that they've been having in New South Wales, they are high enough to give them severe disease in their mid-30s. I have a patient in his 20s. I have another in his 30s, progressive massive fibrosis, who will need a transplant probably within the next 3 years or so. So silicosis has always been more rapidly progressive than asbestosis, but it is dependent on the dose. If you have very low doses, you'll have a very long latency period before severe disease occurs. So if we can prevent people having the high exposures, then in theory, what will happen is that these people will develop silicosis after they're dead. That's what I want. So it is dependent on the dose. Silicosis is much more lethal and much more dangerous than asbestosis because you have a lot of other diseases that it causes as well.
Mr. Buttigieg, you've got one more question?
In the interest of time, yes. So if I could just relate that to an earlier discussion we had about the threshold level of measurement. There's this debate around 0.05 versus 0.02. Could you give us some commentary on your views about the efficacy of going down to that lower level and how important it is?
I personally, you go, David. Go, Graham.
So basically, it comes down to breaches of the level. It doesn't matter what line in the sand you have. If you don't enforce it, you're going to get excursions and exceedances and exposure that's going to harm the individual. So the reality is that I have not been able to find a case anywhere in the literature or in my discussions with people around the world where people have contracted silicosis because their exposure was at or below the workplace exposure standard of the day. All the cases have been where there have been breaches of and non-compliance with the exposure standards. Exposure standards do not save lives. They drive a process to improve the systems and procedures and practices that save lives. But just having a line in the sand doesn't do it. You have to comply with it, and you need to protect people before they get to those severe exposure settings.
I need to give the opportunity to the government to ask a question, so I'm going to now pass to the Honourable Taylor Martin.
Thank you, Chair. But I think Dr. Yates wanted to add something there at the end. Is that right?
Thank you. Yes, please. I'd like to. The point about the levels of exposure is that silicosis is a disease which is produced by cumulative exposure. So if you have a small dose for many years, to the level that will give you disease, or if that's then added to a very high dose because you made a mistake earlier. So the issue about the level is actually very important. We all acknowledge that people will not keep to the level that is legislative, even if they try to, but I personally do not accept the fact that you can't measure at that level carefully. I think that if we try hard enough and we use appropriate research, we will probably get to the measurements where we would be able to legislate and produce a level at 0.02. And that is certainly the level to which the international community is moving. So in order to prevent this disease, which is going to be extremely important, and just silicosis types of silica exposure diseases, then we need to move towards standards that prevent all disease, not just most diseases.
Well, I'm glad I asked if you wanted to add more, because you've literally just covered the question I was about to ask, which was to elaborate on the cumulative nature of silicosis and the exposure. Is it fair to say, with asbestos and mesothelioma, one fibre can kill? I remember hearing that time and time again growing up. But this is a different set of circumstances.
This is a different set of circumstances. Mesothelioma is actually slightly different also from asbestosis, which is the procrosis equivalent to silicosis. But with lung cancer and silica exposure, again, it is a cumulative exposure. The more you have, the more likely you are to get a lung cancer, whether or not you've smoked. So it's a very important concept which we tend not to sort of think about. So you were quite right. And essentially, if I could wave a magic wand, I'd stop everything going into the lung. Cigarettes, dope, silica, dust, everything, other than pure clean air. I know that's a fantasy, but it would stop people from having chronic lung diseases and save us all a huge amount of trouble.
On that note...
Thank you for the work you do.
Yeah, just quickly.
No. Sorry, Mr. Buttigieg, we haven't got time. I'm sorry. We have run out of time, and I've got Professor Driscoll to come on next. So I'm sorry. We are. If there are further questions, members can put them on notice. For the witnesses, thank you very much for appearing today. The committee will be in contact with you for the questions that you've taken on notice, and you'll have 21 days to table those. We'll now just quickly switch over witnesses, and I thank you very much for your appearance today.
Thank you.
Happy to assist.
Professor Driscoll, can I please just do a quick audio check with you to make sure that you can hear me and that I can hear you?
Sorry, how about that? I can hear you well.
Thank you very much, Professor Driscoll. Do you have a video link that's available, or is it audio only?
Yes, I had them. Sorry, I had them both turned off in preparation.
That's okay. It's usually a bit of a technical issue that we have with the setup in this room. So it's just good to know that you're completely active and online. We'll welcome you now to this inquiry. Professor Driscoll, if you could state your full name and position title and swear either an oath or affirmation.
Yeah, my name is Timothy Robert Driscoll, and I'm here representing the Cancer Council Australia. I'm chair of the Occupational Environmental Cancer Committee, or Carcinogens Committee of Cancer Council Australia. And my normal job is I'm a professor of epidemiology and occupational medicine at the University of Sydney. And I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much, Professor Driscoll. I'd like to invite you to make a short opening statement, please.
Fine. I'd just like to start by making a disclaimer to say that I did some work for iCare last year and the year before on Schedule 1 of the Workers' Compensation Act, looking at dust diseases. It's not directly related to what we're talking about today, but certainly is related. So just so you know that.
Thank you very much.
I mentioned the Occupational Environmental Cancer Committee of Cancer Council Australia, and that committee focuses on exposures experienced in work and the environment that increase the risk of cancer, and our aim is, of course, to decrease that risk. And we made a submission along with Lung Foundation Australia, which is Australia's peak NGO on lung health, but I'm speaking specifically for Cancer Council Australia here. People would have had a chance to have a look at the submission, but just to go over the key aspect of it. The focus is silica exposure and silicosis arising from exposure working with manufactured stone. And Cancer Council Australia is certainly very concerned about that, but it's not, from our point of view, it's not just silicosis, but the fact that people are being exposed to silica, because silica is a known lung carcinogen, so known to increase the risk of lung cancer, which we're, of course, particularly concerned about, but also concerned about not just exposure in the manufactured stone environment, but also silica exposure more widespread in the workplace, because there are literally tens of thousands of people who are exposed to silica on a fairly regular basis. A few points that I wanted to particularly make. We're very pleased that New South Wales Government had banned dry processing of stone, of manufactured stone, and the notification system and the case finding system, which are all we're very supportive of. But there is still quite a bit to do, we feel. One is we're very supportive of a ban of manufactured stone, and there's a few reasons for this, but in particular, it's very difficult to work safely with that stone, no matter what controls you have in place, even in very good factories. But we need to keep in mind that much of the work in the factories is done in very small factories that don't have good resources and don't have good knowledge. And also there's quite a bit of cutting that takes place at the place of installation, where it's much more difficult to control. The stone isn't manufactured in Australia, and there are clear alternatives. So we think a ban is appropriate and can reasonably achieved without harming, from a business point of view, things too much. So that's one thing. Second, the exposure standard for silica, which has been changed in New South Wales and most jurisdictions recently from 0.1 to 0.05 milligrams per metre cubed, which we are certainly supportive of. But to be a health-based standard, so that's one designed to stop people getting whatever disease the exposure's causing, it really ought to be lower, and there's very good evidence to say it should be down at 0.02. The reason it wasn't put down to 0.02, as I understand, was concerns about whether it can be appropriately measured. And there's pretty good evidence that it can, but not everybody agrees with that. And so if it can't be measured at that level, if it's felt there's problems, then we think that there needs to be good work put in to make sure you can measure it down to that level well, although our feeling is that you can. The third thing is, I mentioned before that there's tens of thousands of workers in New South Wales who are exposed to silica on a pretty regular basis. And so it's very important that they know the risks and are educated in the risks, and that the exposures are controlled as well as they can, and that the standard that is in place is enforced. Fourthly, we mentioned about low-dose, high-resolution CTs. At the moment, as part of surveillance and screening of people exposed to silica, chest x-rays are used, and there's very good evidence that chest x-rays are not good at picking up silicosis in its early stages. And so there's debate as to whether it would be appropriate to have high-res CT for lung cancer. There isn't good evidence at the moment to say that that would be appropriate in this situation. But certainly if there's going to be scanning done, low-dose, high-res CT is better than chest x-rays. And finally, we're very keen to have a nationally consistent approach. And I know that's not completely within your control, but to the extent that you can achieve that, we think that that would be best. And that's it.
Thank you very much, Professor Driscoll. I'll now pass to the committee for questions. Mr. Shoebridge, would you like to lead the questioning?
Thanks, Chair. Thanks so much, Professor, for your submission and your nice pithy opening. I might just try and unpack a few of those.
Sure.
In terms of in terms of the CT scans.
Yeah. Low dose, high resolution.
Thank you. Low dose.
I get mixed up with that regularly.
We'll start again. In terms of the low dose, high resolution CT scans,
yes.
That isn't mandatory in New South Wales. It is mandatory in WA. Is it achievable if the government had the will? Is it achievable to actually have that as the default diagnosis model across New South Wales?
Almost certainly so. There might be some problems in rural areas in terms of access. But in most, certainly metropolitan, and I would think regional areas, it should be achievable. But I have to say I'm not sure in the rural areas, but there would be some thoracic physicians who could give you some good advice on that.
My feeling is if you can do it in WA, you could probably do it in New South Wales.
Yeah, you would think so, I agree, but I don't know for sure.
The government, the iCare submission has said that they are engaged in a process of artificial intelligence analysis of lung x-rays as a way of having an enhanced diagnostic capacity. What's your position on that?
Look, I think it's useful, but it's not an area that I know a lot about. The advantage is that chest x-rays and high-res CTs can be difficult to read. I mean, that's the argument against about it. But I don't know the details of it, so I can't speak.
But that would be no substitution for low-dose, high-resolution CT scans, would it?
Sorry, you're saying artificial intelligence of chest x-rays, reading of chest
x-rays?
Correct,
chest x-rays.
My understanding is that would not be a good substitute. As I said, I'm not an authority on it, but all the things that I've read would suggest low-dose, high-res CTs would be better.
All right. Could I ask you about the exposure standard? As a result of pushes over the last few years, the exposure standard has been reduced to 0.05 milligrams per cubic metre measured over an 8-hour workday. But that's not actually founded in any health advice, is it? That's still an unsafe level of exposure, is what the balance of the medical evidence suggests.
Correct. There's very good evidence to say that 0.05 is still too high. There's good evidence from overseas showing how the risk decreases with decreasing exposure, but that at 0.05, the risk is still much higher than the level that we would normally expect is reasonable for somebody who's working a 40-hour week and working.
Yep. So that is why you say 0.02 should be the test. Is that can we test to that? Can we actually detect it at that level, which is often what's thrown back against us when we make that recommendation?
So the understanding we have from talking to occupational hygienists is that yes, we definitely can test at that level, but it has been questioned. And if that's the thing that's stopping getting a standard of 0.02, which is a health-based standard, the appropriate standard we feel, then work should be done to ensure that we can measure down to that level. But we think you can now.
But either way, we should not be accepting a demonstrably unsafe level of dust exposure as a national or a state safety standard. That's not sustainable, is it?
Or we believe not. No.
But my final question, there's plenty more I'd like to ask you, Professor, but time is short. My final question relates to actual case numbers. If you look at the iCare numbers, they show there was a trickle of cases leading up to 2017-18, then it starts to rise, comes up to a peak of well over 100, I think it's in 2019-2020, and then, or 2018-19, and then it's fallen away again in the last few years. And particularly in the last, the first part of this financial year, in the previous financial year, we saw a substantial reduction in silicosis cases being confirmed by iCare. Would COVID have had a part in that, or is it because there are just less cases because we're getting all the workplace conditions right?
I don't think I don't think it will be the last one because it would be too early for a change in workplace conditions to have resulted in that. I suspect COVID-19 has had a role, but I also suspect that initially there were a lot of cases that had been not diagnosed and that had occurred over a number of years that were identified in a short space of time. So probably the initial peak that were found was not reflecting how many cases per year, but a build-up of a couple of years, but all diagnosed in the 1 year, so looked artificially high. And I suspect now because of COVID-19, it's now looking artificially low. There's also the problem that not everybody who's potentially at risk, so who's worked in this industry and so has been exposed, not all of them have undertaken appropriate surveillance. So we definitely wouldn't have identified all the cases that were out there.
Can you give any indication of what the underreporting is, or is that kind of one of those Donald Rumsfeld's known unknowns?
Yeah, exactly. I don't know. Victoria's got actually a very good surveillance program in place. They are also having issues identifying all the cases, but they would be able to give a better indication, but I don't have that information in front of me, I'm sorry.
Thanks, Professor. Thanks, Chair.
Thank you very much, Mr. Shivridge. I'll now pass to Mr. Diadam and then I'll go to Mr. Amato.
Thank you, and thank you for your attendance today, Professor Driscoll.
My pleasure.
I wanted to ask you, you mentioned in your opening statement about the work that you did for Hsrs about extending the definition of dust diseases. Are you able to tell us the status of that report? Is that a report that's now in the public domain, or what is the status of that report?
Well, it's been given to iCare, and I thought had been given to the committee that was looking after that legislation, but I don't know for sure. I've definitely finished it. It's in its final form, and it was with them many months ago, but I don't know the fate of it.
I see. So you're not in a position then to answer questions about that work?
I actually don't know whether I'm allowed to or not. I guess it's tricky for me to tell you anything specific about it.
Can I suggest? I was going to suggest on notice. Yeah.
Seeking some advice, and if possible, obviously we don't want to put you in a compromising position, but if possible, if you could tender that report and provide to the committee some advice on the general status of.
Sure. I'd have no problem talking about it. That's perfectly fine. It's just that I don't feel I can without checking with them.
Sure.
Would it be possible to get the professor's view on behalf of the organisations he represents rather than as encapsulated in the report?
But if it hasn't been released publicly, it's hard for me to comment.
I think, Mr. Shivridge, in the first instance, he's...
The professor in that situation.
Well, I was going to say that the professor has taken the question on notice, so I'm happy that he can seek whatever guidance he wishes to take about how he answers the question, and he'll have 21 days to provide us with a response. Mr. Diadam, you've got the call.
Yeah, no, look,
so can I just ask a follow-up, Mr. Diadam, just to clarify? I'm thinking about what I give you. So would you want the report, or do you want a summary of the report, or is the particular aspect of it that you'd want?
Well, I mean, obviously the whole report would be preferable, but if a summary is all that you're able to provide, that would be fine too. I mean, we're interested in the thinking behind any recommendations around expanding the definition. And we've had a number of submissions that have recommended a change to the definition of dust diseases, given that it was first put in place in 1942. The arguments are that it doesn't properly encompass the current situation and the current state of knowledge about the impact of occupational hazards, dust hazards on causing diseases. So, yeah, I mean, if you're able to provide some general comments about that question, or maybe I can phrase it this way. The Morris Blackburn submission recommends a change to the definition of dust diseases to expand its ambit. What do you think of that submission?
Okay, so from a general point of view, I think the current legislation, and this has nothing to do with what I've written in the report to ICARE, I'm just telling you with my occupational environmental physician hat and council hat on. The dust diseases legislation really comes out of a historical context where there were major problems with dust diseases in New South Wales, and there was a focus on particular diseases within that. It raises an anomaly or a challenge, because why would one particular type of lung disease be included and not another type of lung disease be included? And as an example, say something like occupational asthma, which can be caused by dust, but can be caused by other things that are not dust. And so is it appropriate to include occupational asthma caused by dust, but not occupational asthma, which would affect the same worker in exactly the same way if it was caused by non-dust exposure? And it's hard to know that. Now, should one work-related lung disease have a higher priority than another, or the same disease caused by different exposure, should it have a different priority to another? And there's no easy answer to that thing. So that's really what you as a committee would need to deal with. And I think that's the main argument behind thinking about what should be included or not, is to what's the point of the legislation? What are we trying to do in terms of protecting workers or giving appropriate recompense to workers? And you can then extend it to say, well, if you expanded it to include all occupational lung disease, let's say, then the argument is, well, why lung disease and why not liver disease, or why not some other sort of disease? So there are some difficult decisions to be made in there, but certainly I think it would be anomalous to include an exposure or a disease caused by one exposure and not include that same disease if it happened to be caused by a different exposure, for example.
Thank you. I'll hand over to another committee member now, Chair. Thank you.
Thank you very much, Mr. Diadam. Mr. Amato, you have the call.
Yeah, thank you, Chair. Thank you, Professor, for taking the time out to be here today. Professor, in the opening statement, you mentioned this on work for ICARE.
Yes.
Yes. So, Professor, so is it sensible or desirable for ICARE to continue using the existing network of radiology providers and respiratory physicians alongside their own physicians to take and report on CT scans for workers exposed to silicosis? And do you see any benefit or risk to ICARE providing its own CT scanning service?
Yeah, I think that's not something I can comment sensibly on. Not because of the work I've done for them, but it's not really an area I know enough about to sensibly comment on, I don't think.
Okay.
I'm not trying to weasel out of it. I think I don't know enough about it to sensibly advise you.
Okay, I'm not sure if I can ask you the next question. I'll ask you just the same anyhow.
Yeah.
But so did you know that ICARE provides CT screening through third-party providers for anyone exposed to silica in the workplace at no charge?
I knew that it was provided. I didn't know it came through ICARE, but I knew that it was provided, yes.
No. Okay, thank you, Professor. I'll pass it on, Chair.
Thank you very much, Mr. Amato. Mr. Buttigieg.
Thanks, Chair. Mr. Driscoll, thanks for appearing. I just wanted to tease out something we were pursuing with the previous two witnesses about this level, you know, the whole controversy around the 0.05 vis-a-vis 0.02. And there was conflicting evidence in the sense that, you know, I don't want to make too much of it because I think everyone agrees the lower standard's better, but there's a view that the line in the sand doesn't matter. It's all about enforceability.
Yeah.
But I think the point that Professor Yates was trying to make was that it does matter in the sense of a cumulative assessment. In other words, you talked about the dose. So if I've got this correct, would the example be that if I were exposed to 5 different sites, for example, at a rate of 0.05, then clearly the dosing is 5 times 0.05, and therefore the line in the sand of 0.05 could be misleading. And is that why it's important to go down to 0.02? I just was a little bit confused about.
Yeah, I would say no. I'd say that's not the reasoning. I think it basically comes down to the risk of developing whatever the disease that the standard's meant to protect from, and in this case it's lung cancer. So that's what the standard is designed to protect. It's not silicosis, it's lung cancer. The risk increases with increasing dose. So the more you're exposed, the higher your risk. So if you had 5 workplaces at 0.05, then your total dose is much higher than if you had 5 workplaces where the standard was 0.02, provided that was kept to, of course. But if that's the level of exposure that you had, you'd have much higher exposure at 0.05 than you would at 0.02, and so your risk would be much higher. But you can't get to zero risk. We couldn't function as a society if all our standards were zero. So you've got to have a cut-off somewhere. And the question is, where is the cut-off? And most of the time, the stated approach has been if there was a lifetime risk of an increase of 1 in 1,000 of getting that outcome in exposed people that they wouldn't have, compared to if they weren't exposed. And you could argue about whether 1 in 1,000 is the appropriate cut-off mark, but that's where it's generally put with standards, to the extent that we can estimate that. And it's very clear that at 0.05, the increased lifetime risk is much higher than 1 in 1,000 than it is when the level is at 0.02. And when you get to 0.02, it's about 1 in 1,000. So that's the logic behind having it at 0.02 rather than 0.05 or 0.1.
So does that mean, Mr. Driscoll, that Professor Driscoll, I'm sorry.
No problem.
Does that mean that if you have, at the moment, let's say we air monitor, you can air monitor for this stuff, right? So you measure 0.05 at X tunnel or whatever the workplace is.
Yep.
And employee Y has been exposed to that for a period of 1 hour. I'm assuming that the risk is relatively low because it was at or below 0.05. But the problem I think we've heard here today is that we have no idea of the volume of exposure, because he could have been at another 20 sites and we don't know at what level of exposure those sites were at. So there's no way of knowing the dosage, or you pick that up from the CT scans.
No, you won't pick it up from the CT scans, and it's right that you wouldn't know the dosage unless people are wearing monitors all the time, which I think isn't realistic. But that's showing why it's important to have an appropriate standard and to make sure that standard is enforced, because the standards are developed presuming they're saying if somebody's exposed at this level for 40 hours a week for their entire working life, what's their excess risk? And that we as a society have said, well, if the excess risk is more than 1 in 1,000, we think that's too high. And at 0.05, the risk is much higher than 1 in 1,000. At 0.02, it's close to 1 in 1,000. That's the argument for a health-based standard of 0.02.
Okay, so Professor, so that pinch of 0.05 is greater than 1 in 1,000 chance based on a 40-hour working week, is it, in that industry?
It's assuming of somebody having exposure for a 40-hour working week for a working life of 40 years.
Okay, thanks. That's very helpful. That's all from me, Chair.
Thank you, Mr. Buttigieg. Mr. Shoebridge, I'm happy to come back to you now if you wanted to ask some follow-up questions.
Yeah, I do. Again, Professor, thanks for your pithy and direct responses.
Not too pithy.
Yeah, well, it's we all like short. Have you had a look at the scheme, the iCare report at all, or the iCare submission to this inquiry?
No, I haven't seen it.
Yep. So, were you at all aware of the fact that iCare is facing an eye-watering deficit for the dust disease scheme that's in the order of $833 million?
I think I heard something on the news about it a few weeks ago, but I know nothing else. No.
Well, there could be one other part of iCare. Every single part of iCare has an eye-watering deficit, but the one I'm talking to you about is the dust diseases scheme that's in front of us, which is like 59%.
I didn't know specifically, yeah.
If you were to, from your perspective, work out the best way of reducing the future costs to the scheme, from a health perspective, what do you think would be the best way of reducing those future costs to the scheme and bringing that deficit under control?
Well, even completely separate from the cost of the scheme, just in general, an appropriate moral approach to society is to prevent people needing the compensation in the first place. I presume a lot of those costs are coming from compensation, and the best way to avoid the cost then is to avoid the compensation having to be paid by people not becoming unwell. So I certainly think, strongly feel, and the organisation strongly feels, that the best approach is prevention. And to prevent it, there's no doubt that the risk of getting the disease is directly relevant or related to exposure. And the higher the exposure, the higher the risk, which is bad. But on the other hand, what's good is the lower the exposure, the lower the risk. So whatever we can do to appropriately lower the exposure and make sure that the exposures are kept low in the working environment, the better off the worker will be. And also, as a result of that, the better off the scheme will be.
But if you're looking at, say, manufactured stone, when you're looking at the hierarchy of how you respond to a risk in a workplace, the first option that you should consider is actually removing the risk. And exactly. I think it's part of what's informed your recommendation to ban manufactured stone.
Exactly. So the standard approach is using this hierarchy is you eliminate the risk if you can. Now, we can't actually eliminate the risk of silica in the working environment because in some places you just can't. It's a very common exposure. But in manufactured stone, there's no doubt you can. And so the question would be, well, is there some way, if there's some reason you don't want to ban it, is there some way you can work safely with it? And there's very good evidence to say that you can't work safely with it. So then I'm thinking, well, is it necessary? Is there any alternative? And there are clear alternatives to it. So if you can't work safely with it and there are clear alternatives and it's causing terrible ill health with a condition that's completely preventable, it's hard to argue that it should remain, we feel.
Indeed. Could I ask you about the silicosis as a result of exposure to cut sandstone, and particularly the very large number of infrastructure projects that have been cutting through Sydney sandstone through tunnelling? Has that caused any kind of spike or surge in silicosis claims? Because Sydney sandstone has an extremely high silica content.
I'm not aware that the recent, say the last 10 years of work has resulted in an increase in claims, but I wouldn't have expected it to, I'd have to say, because fortunately when people are exposed in tunnelling, the levels of exposure are nowhere near the levels that people get working with the manufactured stone. And silicosis is a disease that can take many years, sometimes several decades, before it becomes apparent. So I wouldn't be monitoring the effectiveness of the controls by looking at the silicosis cases. I mean, we should be monitoring that, but that's not going to be a very sensitive monitor. We should be spending a lot of resources monitoring the exposures, making sure they're kept low and having a good system in place to keep them low.
So this is air monitoring and workplace monitoring.
Air monitoring.
good
and personal monitoring.
Yeah, and good workplace regulation. Because if we're waiting to see the cases, we're 10 years behind the curve, is that right?
Yeah, probably more than 10 years behind the curve. Definitely, you shouldn't be monitoring the effectiveness of current controls by looking at the rates of silicosis currently. The reason that we found out about manufactured stone is, unfortunately, the levels were so horrendously high that people were developing silicosis within 4, 5, 6 years, and very severe silicosis. But in tunnelling, there may well be people who are being exposed to levels that are too high that will get them to develop, cause them to develop silicosis. But that silicosis probably won't be clinically evident and perhaps not radiologically evident for 10 or more years.
So just to take that evidence and that analysis back to manufactured stone, so through changes that have been put in place, that in many workplaces, the obscene level of exposure has been reduced. So that means those rapid onset cases have been reduced in number. Can we say that?
Yes, I think you can say that.
But there is still, even applying the current Australian standard, this persistent overexposure to silica that heaven knows how many thousand workers are facing. And what that may actually mean is we've kicked the problem 5 or 10 years down the path, and that long exposure, gradual onset may well just that may be the effect of it, just pushing the exposure 5 or 10 years down the path.
Well, I think it will mean there will be less cases, and the cases that do occur, by and large, will be less severe, presuming that the exposure is much better controlled. But there is still concern that the exposures are much too high.
Yeah, less overall cases, but the cases, and perhaps less aggressive early onset. But the cases, if we're looking at incidents and following sort of eye care data on incidents, that is not going to show us what's going to happen in 5 or 10 years' time.
The eye care data, you probably are not going to see the effectiveness of this in terms of controlling lower levels of silicosis from lower levels of exposure. Wouldn't be expected to see that for more than 10 years, I would think.
Mr. Shoebridge, I've got some other members who are seeking the call. Mr. Buttigieg wanted... Mr. Buttigieg, then Mr. Martin, and then Mr. Diadam, and I'd say that will probably take us up to time. So, Mr. Buttigieg got the call.
Thanks, Chair. I guess it was really just a point of curiosity on one of those that sort of contrast between the engineered stone industry and the, say, tunnelling, the emblematic example of other industries, although there's many other situations. Is it related to the severity in the engineered stone? Is it related to the granularity of the byproduct? In other words, in tunnelling, I would imagine that the byproduct is coarser. I may be totally wrong about this, and then therefore the exposure to fine grain particles is less, and that's why part of the reason why engineered stone is a greater risk. Is there any validity to that, or is that not how it works?
Look, there's a range of things that contribute to it. Really, the biggest problem or two big problems with the engineered stone or manufactured stone is their levels of quartz are incredibly high. They can be in the 90%, whereas that's usually not the case in the tunnelling work. I mean, there can be situations where it is very high, but with the manufactured stone, it can be incredibly high, and the environments in which they work, the exposures are not controlled. So the workers are being exposed to a lot of dust, and the vast amount of that dust is quartz. In tunnelling, the exposures are much, much better. It's not to say that they're always well controlled, but even when they're not well controlled, in 21st century Australia, they are just nothing like we've measured or has been measured to do with manufactured stone. In terms of, you were talking about the size of the particles, look, it's not my area of expertise, but the size of the particle certainly is important. and there's definitely a problem of small particles in very high amounts with manufactured stone.
Thank you, Professor.
Mr. Martin.
Thank you, Chair, and thank you for your time today, Professor. If I could just draw your attention in your submission under the headline, A Nationally Consistent Approach to Silica Regulation. Are you aware of, in your work with the Cancer Council, any discussions or efforts to bring the different states together to get something nationally uniform together?
You mean that Cancer Council is working on?
Or involved?
Just in general. So Cancer Council has been working with a number of other groups, like Lung Foundation Australia and a number of other groups, writing submissions to the relevant ministers in each state and territory about these issues, including trying to get standardised regulations.
Mr. Munn?
Sorry, that was all.
Thank you, Mr. Martin. Mr. Diadam.
Thank you, Professor Driscoll. Earlier in the day, we heard evidence from the CFMEU that was very critical of the Golder report, the case finding study that had been commissioned by Safe Work, I believe. Do you share their concerns about the quality of that case finding study? That it's, I think the suggestion was that it wasn't actually a genuine case finding study, that it was very much a sort of desktop based analysis of existing data rather than a proper epidemiological exercise.
Yeah, unfortunately I haven't read the report. I didn't realise it was accessible. I'd be happy to take that on notice as well if you would like. If it's accessible, if I can see the report.
Yes, it's actually one of the attachments to the Safe Work submission to this inquiry and should be available on the inquiry website.
Okay, and the same with the CFMEU comment?
That'll be available in the transcript.
Okay. Yeah, sorry, I haven't read it, but I'd be happy to have a look and give you a comment if you'd like.
That would be appreciated. Thank you. That's all I have, Chair.
Thank you. I'm just going to quickly look around the rest of the committee to see if anybody else has got any final questions. If not, we are almost out of time. So given that everybody's silent, Professor Driscoll, thank you very much for making yourself available today. It's been most valuable. And the questions that you've taken on notice, the committee will be in contact with you to be able to have those tabled within 21 days. We'll now take a short break and return for the late afternoon session at 3:30 p.m. Thank you. Well, welcome to the final session of today's hearing for the dust diseases inquiry. I'll now welcome our next witnesses. Mr. Cullen, if you could state your full name and position title and swear either an oath or affirmation. Thank you.
Sure. David Cullen, Managing Director of Caesarstone Asia Pacific. I will take the oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much, Mr. Cullen. Mr. Isherwood.
I'm Gary Isherwood. I'm the General Manager for Stone Ambassador Pty Ltd. And I'll take the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by myself shall be the truth, the whole truth, and nothing but the truth.
Thank you very much for that. I'd now like to invite both of you to make a short opening statement. I'll start with Mr. Cullen.
Firstly, thank you for the opportunity to participate today in front of the Standing Committee on Law and Justice and the 2021 review of the Dust Disease Scheme. Caesarstone is one of the leading suppliers of engineered stone in Australia, having commenced operations in Australia in 2000. Engineered stone is fundamentally a safe product and safe to fabricate, provided the correct safety practices are employed. SafeWork New South Wales has noted that silicosis is a disease which is entirely preventable if the correct safety measures are in place. We've taken many measures over the years to educate fabricators, keep up to date with the latest research and protective measures, and ensure our products are handled in a safe manner as part of an industry-wide effort to raise awareness and encourage change. These measures have been comprehensive and not limited to, but including updated and regularly distributing material safety data sheets, introducing fabrication manuals, providing health and safety information and guidance and training to fabricators, warning labels in multiple languages. Since the previous inquiry in 2019, Caesarstone has continued to invest in the education of the industry. In 2020, we appointed a full-time environmental health and safety person to work closely with industry. In April 21, we launched our online program called Master of Stone, which is a series of 8 online modules directed at employees and management of fabrication businesses. To date, we've had 158 businesses register, we've had 398 individuals register, and we've had 1,157 modules completed. In August 2021, we launched a new health and safety program, including a good practice guide for fabricators, a registration process, an enhanced registration process for our Master of Stone training program. We are requiring compulsory information on workers' compensation by fabricator, and we're asking for environmental health and safety compliance agreement forms from fabricators. In 2022, we've commenced manufacturing of low silica product, which will be distributed to the market throughout 2022. We've also been working with iCare for on-site screening, and we've had a number of conversations in relation to real-time silica testers, which is currently being tested in the New South Wales market and looks very positive in terms of implication and application longer term. We've supported many changing practices such as the ban on dry cutting stone over the years. We've also, however, recognised the need for greater nationwide regulation to improve safety for workers across the industries that handle materials containing silica. We agree with the National Dust Disease Task Force final report that said that systematic change is required to improve protection for all people who work in dust-generating industries. We've been and continue to be a strong advocate for mandatory nationwide licensing and fabricators having rigorous auditing and enforcement structure to support it. Caesarstone, individually and through our industry body, ASAG, has been an active participant in the National Dust Disease Task Force process and other federal and state forums related to silicosis and dust disease. We prepared a distribution and distributed a policy paper tackling occupational lung disease, the pathway forward, which sets out a proposed national reform package, implementation plan, and a process to measure the reform's effectiveness. We'll continue to work with federal and state governments, workplace safety regulators and the industry. We believe systematic change can occur if there's a national, consistent and unified approach by governments as envisaged by the National Dust Task Force. Implementation, however, we believe must commence without delay. We're encouraged by feedback from Safe Work New South Wales, who have found an industry willing to change, dramatic changes in the last few years from audits and awareness escalation. With respect, our view is that it should be recommended to the New South Wales Government that they support and collaborate with the federal government to coordinate a nationally coordinated reform package. We're encouraged by Victoria's commencement of licensing, which started in November 21 and will be compulsory in November 22. We also have great empathy for workers and their families who have been impacted by silicosis, but we believe the changes occurring in the industry, longer-term silicosis in engineered stone will be a historical disease. Thank you.
Thank you very much for that, Mr. Cullen. I'll now invite Mr. Isherwood to make a short opening statement as well.
Thank you. I appreciate the opportunity to address here. My employment with Stone Ambassador began in January 2019, and during my time with Stone Ambassador, I have seen some very dramatic and much needed changes within the stone sector within the Australian marketplace. Although the best working practices and the correct manufacturing techniques have always been highlighted and suppressed onto clients by different suppliers within the marketplace, it's obvious that those recommendations have never been treated with the respect or the significance and importance that they deserve by the entire industry. As a responsible supplier, I think we can all say that parts of the industry needed to make vast changes and improvements with respect to overall OH&S needs. From what we have experienced within the various states of Australia during the last 3 years, those changes are occurring and the sector is improving each day that passes. The movement made by WorkSafe Victoria within the engineered stone licensing scheme has been very well received by almost everybody associated within the industry inside of Victoria and within the other states of Australia. And we feel this positive move will really help push the sector into a new phase of development and improvement. At Stone Ambassador, we are 100% committed to improving the industry of which we work within. And as a member of the ASAC group, helping to create a safer working sector for everybody involved. Thank you.
Thank you very much for that opening statement. I'll now pass to the committee members for questions, and I'll start with Mr. Buttigieg. You have the call.
Thanks, Chair. Look, I just wanted to canvass with you, I guess, I'm assuming from the other side of the ledger, although I won't make assumptions given it's what we've got you in as witnesses. We heard evidence this morning from the CFMEU and the AWU that, and I might add some other witnesses from the medical profession and various other quarters that particularly in that engineered stone industry, which you people are in, that elimination is achievable based on the idea that it's very, very hard to minimise the risk to an acceptable level, and the fact that there's possibly substitute materials which would come in and take the place of the current composites that we're using in that industry now. I just want to get your reaction to that and where you sit on those propositions.
I think a couple of points in response. The feedback that we've had from Safe Work New South Wales, which obviously we would consider independent, is that they are seeing an industry that's changing, and the audits that they've completed have been satisfactory. So which would to us indicate that the changes are taking place and they are effective. Secondly, from a substitute perspective, as I mentioned in my opening statements, we are introducing low silica product, and that product will range from 50% down to potentially less than 10% this year. So we believe that that will help improve the environment as well. Generally there are substitutes available in the market. The average consumer has an affiliation with engineered stone because of its attributes, because of its look. We have to make sure it's handled safely. And I think everything we've seen indicates that, and most state governments would agree, that the product can be handled safely. It just has to be handled safely.
Yeah, I mean, in the same, David, of what you've just said. I mean, alternative products are available. You know, we've introduced new products ourselves to offer as an alternative, and also we're in the final stages of development with low silica products to introduce into the marketplace, and a number of suppliers are doing the same and will follow suit. So I think everybody involved in the sector is working very hard to reduce the impact and obviously bring alternatives to the marketplace. But as David said, you know, if manufactured in the right way and obviously covered in the right way, we can get it to a level where it doesn't cause that impact.
So can I, in follow-up to that, that's interesting and encouraging. In terms of the market price, I guess, is there any good reason as to why that substitute couldn't eventually take over? Because I mean, in an ideal world, we can't remove the hazard across the board. Obviously, there's situations where it occurs naturally. You know, tunnels have got to be tunnelled and things have got to happen in that. But in this particular segment of the industry, which we heard on evidence this morning, there's very, very high density of quartz in that material. There's resins, and I don't profess to know all the detail, but the point is that the exposure levels are a lot higher because of the nature of the product, notwithstanding the fact that you can put controls in with PPE and all the rest. My point is this: if there's a feasible substitutable alternative which minimises the risk dramatically, and that's within sight, why wouldn't we be concentrating on going down that path? And if so, is there any economic reason that you wouldn't want to go down that path? In other words, is the substitute twice as expensive, 3 times as expensive, or is it feasibly a similar price?
As of today, there's no substitute that matches the full attributes of engineered stone. You have laminate material, which is not the same. It's a softer material. It's not the same look. It's not the same ease of maintenance. You have marble, granite and porcelain as probably the 3 other main alternate products. However, those 3 products generally also contain silica. And I suppose our view is that our product contains up to 93% silica, depending on the manufacturer, but it's in that vicinity. Our aim is over the next 3 years, the majority of our product will be less than 50% silica. And in conversations I've had, and Gary just mentioned it with Stone Ambassador, with the other manufacturers, they're all headed in the same direction. So we've fully understood that there is a need to reduce the silica level. We believe we can reduce it and maintain the same attributes of the product and make it a viable substitute as such. So it answers your question in terms of substitution. Similar product, just the different ingredients without the high content of silica.
Mr. Buttigieg, I'm just going to pass the questioning over to some other members, but I will come back to you. Mr. Shoebridge, you have the call.
Oh, thanks, Chair. Thanks for your attendance to both of you. Mr. Cullen, you'd be aware, wouldn't you, that Caesarstone has told the United States Security and Exchange Commission that they've been unable to get insurance cover to protect them from claims in relation for people who have been injured from exposure to silicosis from your products in Australia? You'd be aware of that?
I'm not specifically aware of that report or that notation. However, we have insurance in Australia, and we have had insurance since day one.
Right. Well, why don't I read to you from your company's own disclosure to the United States Securities and Exchange Commission. It's from page 108 of the report for assistance to you. Speaking to the global product liability insurance, which is the only insurance coverage you have in relation to silicosis and product liability in Australia. And it says in part, the policy covers only illnesses diagnosed after February 2010. Although we seek to renew our product liability insurance to cover silicosis-related claims, there is no assurance it will be successful in its renewal, specifically as currently Israeli and Australian policies do not cover newly diagnosed silicosis-related claims. Now, that's what your company has told the United States Securities and Exchange Commission. Can we assume that you haven't misled the US Securities and Exchange Commission?
No, we haven't. Just to clarify, we have insurance up until I think it's 2019 that's in place. So any instances prior to that is fully insured. Post that is not.
So you have no insurance cover that a future injured worker could rely upon to protect them if they have a damages claim from exposure after 2019 from silicosis. That's right, isn't it?
From an insurance perspective, it's correct, but we are a sizable business with strong cash flow, both in Australia and also internationally, and we make sure that we meet our liabilities, whether it's insured or uninsured.
Well, also from your disclosure to the United States Securities Exchange Commission, you've made it clear that your collective insurance likely recovery for silicosis claims is in the order of $8 million. And you already have a global exposure valued at least $42 million. So you're already some tens and tens of millions of dollars in the red for silicosis. What protection is there for future injured workers that there'll be assets to meet the claim?
We've never walked away from a liability as a business, either in Australia or internationally, and we would stand by any liability that we may have. In many of those cases, there is a legal argument as to whether we do or don't have liability. In most cases, the majority of the legal recognition as to who has liability sits with workers' compensation. So we potentially have a percentage, but it's a relatively small percentage. And as I say, we are a strong, viable business.
Well, you see, Mr. Cullen, if no insurer will touch you for silicosis exposure, they just simply won't write a policy here for you for silicosis exposure for damage for Australian workers. Shouldn't that be a huge red flag for this committee that your product is so dangerous you can't get insurance coverage for it?
No, I think it's, firstly, I think we believe it relates back to historical cases in terms of the majority of the cases. We think with the changes in the industry moving forward, there are going to be less and less issues. There are obviously going to be historical cases that are going to move forward. However, as I say, we have a strong, viable business with strong cash flow, and we meet our liabilities.
Mr. Shoebridge,
Sorry, Mr. Cullen, it's plainly untrue that this is about historical matters. Insurers are refusing to cover you for damages from silicosis exposure in Australia and Israel for current and future claims. In fact, any claim from 2019 onwards. It's not about historical claims that insurers are walking away from. They're not willing to go near you with a barge for claims from 2019 onwards because they know the level of damage likely to happen, don't they?
Mr. Cullen, before you answer that, I'm just going to indicate that after you've had the opportunity to respond to that, I will pass the questioning over to Mr. Diadam, but I will come back to Mr. Shoebridge at a later time. So, Mr. Cullen, you have the call.
Mr. Cullen, it's not about historical cases. They're refusing to cover claims from 2019 onwards, including exposure that's happening right today in workplaces across New South Wales. That's what they're refusing to cover.
The facts are any case that we've had has been generally, and when I say generally, in excess of 95% has been covered by insurance. Anything that's not covered by insurance moving forward, we will cover as a company.
Mr. Cullen, what you say about 95% covered by insurance is directly contradicted by your company's own disclosure. In relation to silicosis claims, you say you have insurance cover to cover only $8 million, yet you estimate the claims to date globally at 42 million. It's plainly, what you say to this committee is contradicted by your company's own disclosures.
No, I'm clearly saying the cases that we have in front of us, any case that has been settled has been covered by insurance up to around 95%. That is fact.
I'll now pass the questioning to Mr. Jadam. You have the call.
Thank you. Mr. Cullen, we've heard throughout the course of the day stakeholder after stakeholder contradict the statement that you made in your opening statement that this product is safe. I perhaps focus firstly on the question of the workplace exposure standard. We're advised that the product is not safe when there's a workplace exposure of 0.05, which is the current workplace exposure standard in New South Wales. It can't be, the technology is not available to measure at 0.02, where that would be a safe level or a relatively safe level of exposure. Your product can't be safely handled under the current technology to assure workers are kept safe. What do you say to that?
Majority of state governments have said that the product can be handled safely if it is handled safely with the right PPE, with the right ventilation, with the right process and procedures. It can be handled safely. And that includes Safe Work New South Wales, who have said exactly the same thing.
The evidence is that 0.2 is the safe level in terms of workplace exposure, and that can't be measured. How can you say that the product can be handled safely if we can't measure at a safe level of exposure?
Because the experts are telling us it can be handled safely.
I want to also, obviously there's a history in terms of non-compliance within the industry that's clearly led to the number of cases of silicosis that we've seen. There's a particular, I suppose, concern about the installation side of the industry. And, we've had a number of stakeholders put in evidence today that they don't see how it's feasible for the installation side to be monitored and enforcement to be adequately undertaken in relation to that element of the industry. What do you say to that?
I think most of the evidence that I've seen indicates that the major risk is in fabrication, not in installation. Is there risk in installation? There is some risk, but the major risk is in the factory side with fabrication. Majority of installers are employed directly or indirectly by fabricators. As the fabricators have become more educated and as they've understood more that the safe work practices have to be in place both at the factory level and also at the install level, practices have been changing. And I think we'll continue to see those change. It is more difficult on site, but we as an industry are educating our fabricators to make sure that the practices that they need to put in place happen both at an install level and also at a fabrication level.
But how can we be, it's obviously going to be a risk given that we've heard evidence that the compliance measures required to ensure that the installation side of the industry is complying is, beyond the capacities of safe work, that they can't be at the point of installation to ensure that, installers aren't dry cutting or that other practices that are being undertaken are not safe. Why should we be taking a risk with a product that clearly is not essential, that can be substituted? Why should we be taking that risk with workers' lives?
I think because of all the initiatives that the industry is putting in place, including the introduction of lower silica into the market and the substitutes, as I mentioned earlier, porcelain, marble, granite, all contain silica. So those products, even if they were substituted, still have to be handled safely. I think secondly, with the education programs that we've been putting in place and the conversations we've been having with builders and kitchen companies, they are also, and consumers as well, they are all very aware of the silicosis issue because of the publicity, and in the builders and kitchen companies' cases, because of the information that we've given them and the discussions we've had with them, so they're also enforcing. If a builder or kitchen company particularly the builders on site, see activity by fabricators that shouldn't be happening, then they will jump on it. And consumers are doing the same. We hear from consumers if there are issues, and I think everyone's more educated, whether it's the consumer, fabricator, kitchen company or builder.
Mr. Diadam, I'm just going to pass that. Oh, Mr. Diadam, I'm just going to pass the questioning now to Mr. Amato, then Mr. Martin, and then we'll come back to you for a second round. Mr. Amato, you got the call.
Thank you, Chair, and thank you, John, for coming this afternoon. Mr. Cullen, in your submission, inquiry, you mentioned that engineered stone is a safe product and safe to fabricate, providing the correct safety practices are employed. And then you go on to mention safe for abuse. So I was noted that silicates is a disease which is entirely preventable if the correct safety measures are in place. Well, would you perhaps be able to give a bit more of a rundown to the committee about how that is achievable?
I think generally with the right practices and procedures in place, I mentioned earlier, having the right PPE equipment, having the ventilation equipment, having monitoring, having workplace practices, having education on the floor with fabricators. I think it's, we've put out many health guides and fabrication guides indicating exactly what needs to happen, which I'm happy to share with the committee in terms of what needs to take place to create that safe work environment. And the majority of fabricators that we see today are operating with those controls in place. There's always a small percentage of every industry that doesn't always comply, and we're trying to educate that industry so that it's 100%, the rest of the industry, so it becomes 100%. And we believe that with the introduction, as Victoria's doing, with a national licensing scheme, it will take it to the next stage.
I think it was Colin. And another question, you also mentioned about your fabrication manuals, providing health and safety information, guidance and training, so forth, right? Is that available, is that distributed only in English or is that distributed in other languages as well?
It's multiple languages. And if it's required in a language we don't have, then we're happy to translate.
Okay, and that's here in Australia?
Yes, it is, from Chinese to Vietnamese and on. We have 5 languages currently, I think, plus English.
Okay, it's good to know. Thank you very much.
You're welcome.
Thank you, Mr. Amato. Mr. Martin, you have the call.
Thank you. And Mr. Cullen, in your submission here, you talk about the Victorian scheme, the licensing scheme, which I take it is only recently implemented. But are you able to elaborate a bit more on Caesarstone's experience with that scheme, even given that it's the early days?
It is early days. It was announced being effective November 2021. However, fabricators have up until November 2022 to be licensed. It'll be a 5-year licensing scheme that's put in place for each fabricator. We are very supportive of it. We'd like to see some modifications. We'd like to see certification being third-party certification rather than just the fabricator certifying. They've defined engineered stone at 40%. We think any product that has silica should fall under that licensing banner. And also we believe that kitchen companies and builders should be compelled to only purchase from licensed fabricators. So they're the 3 main changes, and the reason for the third one is that a fabricator could import product from overseas and bypass the licensing process. But we believe that those 3... Sorry?
No, go on.
I was going to say, we believe with those 3 changes to what Victoria is putting in place, if that happened at a national level, we would have a move very much in the right direction.
Could you just elaborate a bit more at the end of your answer there, just before I interrupted? You said that products could be imported directly, or even that builders can somehow purchase products from fabricators without a licence. That doesn't really make sense to me. What's the point of a licence if it's not required?
Well, the way the licence works in Victoria at the moment is that I can only supply a fabricator who is licensed.
Okay.
Someone from overseas is obviously not going to be in that position supplying that fabricator. It's a small part of the industry, so it might be 3 or 4%. However, we believe if you cut that loophole off, it just closes any potential.
So I take it similarly, if someone was handling second-hand, recycled, engineered stone, they wouldn't need a licence either?
Correct, but that again is very rare.
Okay. And what kind of a burden do you see that kind of a scheme has brought on the industry down there in Victoria?
I don't think it's going to be significant. I think fabricators will be required to put in place control plans. They'll be then audited over time against those control plans to make sure that what they've said is actually what is happening. There's no fee for the licence, so the 5-year licence is there's no charge for it. The obligation for the fabricator is to make sure that his equipment is up to speed and it's able to provide that safe work environment, which we don't think is exceptionally onerous. There are capital investments that need to be made, but we believe that any fabricator who wants to be in our industry should make those investments or they shouldn't be in the industry.
Right, well, that's very good to hear. Mr. Isherwood, do you have anything more to add on this?
Similar to David, I mean, our headquarters is based in Victoria, and what we've seen since the announcement of the licensing scheme from fabricators in Victoria has been nothing but positivity. There's been a huge shift in the last 2 years with respect to the procurement of capital machinery, which is more sophisticated than what was being used previously. Elements of water suppression and dust extraction, all elements involved in fabrication of engineered stone to improve and to limit, obviously, the risk associated to the processing of the material. As I said, we also travel interstate, and the news of the licensing scheme has it's carried through to other states of Australia, and the industry as a whole is very buoyant and hopeful that will continue through the various states, because they believe that it's the right way to also to control this, and also to I suppose in effect clean up the industry and remove some of those guys who are not conforming, not keeping to the fabrication guides, or playing by the same book.
Well, that's all very good to hear. So thank you for your time this afternoon.
Thank you, Mr. Martin. I'll now pass back to Mr. Buttigieg and then Mr. Shoebridge.
Thank you, Chair. So in your submission, you back in, you support the view that's come through strongly in all day, really, is that the Victorian regime is the gold standard, and you're supporting that regime. I notice you've got a few little riders towards the end of the submission there, but they're all sort of extras, if you like. So it's a fully sort of licensed regime, which is by all accounts deemed to be fairly effective. I just wondered, what's your experience in any other international jurisdictions in terms of, are they doing anything more robust overseas than the Victorian model?
Look, I don't think so from my experience. I think, if you look at the US and you look at Canada, the markets there, they adopted engineered stone well after Australia adopted it. So the issues are not as prevalent in the US or Canada today. But the conversations we've had is we're trying to share our experience, obviously, with our subsidiaries in the US and Canada, so that they move earlier rather than later. So for the last 10 years, we've been putting a lot of things in place in those markets as well, albeit that they started 5, 6, 7 years after Australia. So there's a latency period generally with, not always, but generally with silicosis that takes some time. So not a lot of evidence overseas. From everything we've looked at, and 2 years ago, I talked about an accreditation system that we were looking at from an industry perspective, driven by industry, because we felt it was necessary. That became very difficult for a number of legal reasons. So again, we're quite positive about what we've seen out of Victoria, and we think with some slight modification, it is the way to go nationally. And we would add to it that we have many fabricators who work across multiple states having to comply with multiple laws. So it gets very confusing for those operators of businesses across borders. And if we had a national consistent approach with a licensing scheme incorporated, we think it would make a huge difference moving forward. And then combine that with all the initiatives we're putting in place, including introduction of low silica product.
So just a quick follow-up on it, just a couple of quick follow-ups to that. So in terms of the, the per capita usage, are you saying that Australia is we're probably the highest per capita users of this product, are we?
Outside of Israel, yes.
Okay. And the other thing I wanted to ask you was that outside of this submission, have you been lobbying the government to go down the Victorian path, implement the Victorian scheme?
At every state level and federal and Safe Work and WorkSafe, everywhere we could go, we've produced a number of papers which we've distributed, indicating our view and indicating how things could be put in place. We've indicated support for the Victorian scheme with some modification. We are now just waiting for the response to the National Dust Disease Task Force, which I gather is going to be led by the Attorney General offices around Australia, to see what the recommendations are that come out, along with the work that Safe Work Australia is doing.
So in terms of one of your major competitors, I think, is Smartstone. I mean, I don't expect you to speak for them, but can you throw any light on as to what their position is on this?
I think I'd be safe in saying that their position is along the same lines as Gary and I. They were and are members of the ASAG, Australian Engineered Stone Advisory Group, and we're all generally of a similar opinion. Not everyone in the industry, but generally most of the major players are of a similar opinion.
Mr. Buttigieg, I was just going to ask if you could wrap up your questioning.
There's another situation where we've had 2 or 3 reviews. You've got the industry on board with a licensing system. You've got all the experts saying there needs to be a licensing system, and you've got the Victorian gold standard as the example, and yet the government is dragging its heels. Do you know why is that the case?
I think probably for a number of different reasons. They received the reports towards the end of June. COVID has obviously been a major distraction for the government. I think recent announcements with Greg Hunt's change and the federal election coming along as well is probably the combination of all of it has slowed the process down. But we've been told that towards the end of the first quarter this year, we will get some response that will come from that joint effort with the Attorney Generals and Safe Work Australia.
Thank you, Mr. Buttigieg.
I think, as well as I mentioned in my submission, that I think the more, again, with respect that the states could feed back to the federal government that this is the right approach, I think would put us in a good position.
Thank you for that, Mr. Cullen. I'll pass now to Mr. Shoebridge.
Oh, thanks very much. I assume both of you recognise that the manufactured stone product that you and or your members sell, which contains acknowledged silicon levels of 85% or greater, is inherently dangerous if misused. Do you agree with that starting premise?
I would agree, but I'd also say that's the same as many industries. If you misuse a product or a chemical, it's dangerous.
Mm-hmm. Mr. Isherwood?
Yeah, the same. I mean, obviously, it's the same as anything. If it's mistreated and it's not controlled in the right and the correct manner, then for sure. But that's that.
Well, it's not just like anything. Your product, if it's cut like other similar benchtop products, it's used in the way that other benchtop products are used, those products, whether it's steel or natural stone or some kind of laminate, they don't kill people, but your product does. So it's not the same, is it? Because using exactly the same manufacturing processes for natural stone doesn't kill people, whereas with your product, it does kill people. So it's not the same, is it?
I would disagree. I think over a period of time, with silica in some marble products, some granite products and some porcelain products, if you have unsafe work practices and you're inhaling the silica dust from those products, eventually it has to do some harm.
Yes, but of course, a high level of exposure over a couple of years to cutting of your products kills people, whereas natural stone and laminates doesn't kill people. That's what the doctors tell us. That's what all the studies show. And that's why it's wrong, I put to you, to say your product is just like other products, because there's a bunch of other products in the same bucket that don't kill people in the same circumstances. Do you accept that?
I suppose what we're saying is that, and I agree, our product is not the same as some other products on the marketplace, but any inhalation of silica is not good.
Yeah, but the inhalation of silica from silica dust produced by your products with 85% more or more silica content is especially lethal. And I can't understand why you don't acknowledge that. And if you don't acknowledge that, I wonder if you've got a commitment to dealing with the hazard.
We've never stood back from not acknowledging the fact that inhalation of silica is dangerous. So obviously 93 or 90% or 85% inhalation of silica is dangerous, but the product can be handled safely. It just needs to be handled safely. But any inhalation of silica is not going to end up in a good result.
All right, so we come back to this oranges and oranges argument you have between your product, which has been proven to rapidly kill young workers who inhale the dust, and other products which haven't been proven, and you say that it's an oranges and oranges case. Is that your evidence? They're just the same, it's fine, carry on.
No, I'm not saying that at all. The question that I ask and I look at all the time is, can the product be handled safely? And the answer.
So how many deaths?
Order.
How many deaths per year should Australia accept are acceptable for your product to continue to be in a market?
Mr. Shoebridge.
Is there an acceptable number of deaths in the industry?
Mr. Shoebridge, I'll ask that Mr. Cullen, sorry, I just need to raise the point that if we speak over each other, it makes it very hard for Hansard to be able to record this. So I'll ask that the witnesses be allowed to finish their answers before the follow-up questions are asked. Mr. Cullen, if you can address that point if you like.
Mr. Cullen and Mr. Ishwood, ask it again. What's an acceptable number of deaths per year from the workers who install your products?
There is no acceptable number of deaths. One death's a tragedy. And we accept that we do not want to see any deaths or any injuries in this industry. And that's why we've invested and educated and changed over many years to help make this industry a safe industry. And we're continuing to do that with the investment in further education, low silica, with process, with procedures, with working together with fabricators and state governments and federal governments to take the industry to a place where it can and will be handled safely, which we firmly believe is the case.
None of your products in the Australian market at the moment is low silica, Mr. Cullen.
As of today, no. As I mentioned, we're in the final stages of manufacturing and we'll be releasing low silica product this year.
Mr. Isherwood, we heard from occupational physicians and others that a significant amount of imported manufactured stone is going direct to construction companies, direct to developers and builders. You'd be aware of that, wouldn't you?
Yeah, obviously in some instances, budget dependent, builders do bypass the relevant channels that they should be respecting to control obviously the import of the material and the safe working practices needed around the material. That's something very difficult, which we can't control, but obviously we fight against that in all the various states of Australia on a monthly basis, and it continues.
Mr. Cullen, you'd be aware of the practice?
It is a very, very small part of the market. It does happen, but it's a very small part of the industry. The challenge is by the time you bring the product in from overseas, particularly products and builders, if they're going to look at doing it, they'll generally do it cut to size. And the cut to size, if you're dealing with apartments, which is generally where this product that's bought in directly would happen, has lots of practical issues related to it, and that's why it's very rare that it happens. It does happen, but it's a very, very small part of the market.
Yeah, but what evidence do you have that it's a small part of the market? How much of your product sold goes to those those sales directly to construction companies?
None that I'm aware of, because we're distributing only to fabricators. Unless there's imports indirectly from overseas, which I greatly doubt, it doesn't happen.
Is there a ban on the direct provision of manufactured stone to construction firms, avoiding all of those highly questionable, at my point, but nevertheless, checks and balances in the balance of the industry?
There's no ban that's in place. However, if you look at the product comes in 3 by 1.4 metre slabs generally. Some other versions, but that's probably the majority of the marketplace. It has to be cut. It has to have sink cutouts. It has to have tap cutouts. It has to be polished. It has to be installed. So there's a whole process. So it's very, very rare that it's going to avoid the fabrication process. If it were to avoid the fabrication process, qualified installers would have to install the product.
Mr. Shoebridge, I'll have to ask this. Mr. Shoebridge, your final question. Thank you.
Final question. Yeah. You see,
finished.
Well,
sorry, Mr. Martin.
Drilled the last one, Mr. Cullen.
I was just concluding on the installation side. Generally, the installers are going to be part of a licensed if they're licensed, such as Victoria, they will be part of a licensed fabrication business, and they may just be installing.
Mr. Isherwood, you would accept that direct importation, which goes directly to construction sites, avoids 99% of the risk avoidance measures that have been put in place, at least in New South Wales, don't they? None of those, that's not been oversighted by Safe Work. It's not part of those small manufacturers that Safe Work say they've been looking at. It just avoids it all, doesn't it? It's a major safety risk for your products.
I think, Mr. Shoebridge, we have two instances. We have instances where a construction company can procure material in slab format from overseas, but they designate a fabricator within Australia where the material will be delivered to and fabricated, and therefore bypass a handling fee with said fabricator, and they're dealing with a supplier overseas and buying the material direct, which then ultimately the controls and obviously the risk is still here in Australia. The other side where a construction company can buy direct is purely on the basis that David mentioned, which actually, in all fairness, is a very low percentage of the marketplace here in Australia, which is prefabrication, which is manufactured overseas to specific sizes required for the commercial project, for instance, delivered into Australia and then purely installed. So there's two areas. The first area doesn't really resolve anything. It's just bringing a problem in, but is a possible chance to bypass any measures that we have in place or any licensing scheme, which is what we really need to look at how we control that moving forward. The second, it does occur, but the small percentage of the marketplace is based around prefabrication bench tops.
Thank you for those responses. Yes, I'm just going to pass now to Mr. D'Adam to continue his line of questioning.
Thank you. Mr. Cullen, you said that any death is a tragedy. Obviously, we want to avoid deaths and injuries to workers. there's some urgency here. Shouldn't New South Wales just move now rather than waiting potentially 2-3 years before a national scheme can be put in place?
I suppose, given that we're in February, we expect and we hope that there's going to be some announcements towards the end of the first quarter at a federal level. So we're hoping there'll be a recommendation at the end of the first quarter for federal approach to licensing. If that wasn't the case, or if it was going to be too difficult for that to be, given we're a federation, to get that across state by state, then we definitely endorse New South Wales running with something similar to Victoria with the modifications that we propose.
Just on that, I mean, obviously if New South Wales goes with a model similar to Victoria, that's the vast majority of the national market. That's going to shape the parameters of any national scheme that ultimately gets adopted, isn't it?
I would think so. It's going to be approximately 70% of the market.
Do you see any merit in extending the licensing to workers? At the moment, the Victorian model only licenses the PCBUs. If you had a licensing system that extended to the workers who are handling the material, that obviously has benefits in terms of ensuring the workers are properly screened, that they're properly trained, that safe practices are really extended to those areas where perhaps the fabricators don't have a direct line of sight, like installing. What do you say to that proposition?
Mr. D'Adam, before we do go to Mr. Cullen, I just wanted to give you the opportunity to, and you can probably guess where I'm going to go with this, PCBU.
Oh, sorry, a person controlling the business unit.
Thank you. Mr. Cullen, if you could provide a response.
Is it an undertaking or business?
Sorry,
person conducting an undertaking or business.
Mr. Cullen, you have the call.
Sure. Subject to what the licence requirements were, as of today, we're reliant on the owner of the business or the business itself to be licensed, and then for the requirements of the licence, which would include, I think, majority of those requirements on the individuals employed by the fabricator. So it's an extension of it. If it was feasible and subject to what the requirements were, then it'd be something that we should consider. However, there's lots of discussions around the installation side of it. The majority of installers are employed directly or indirectly by the fabricator. The fabricator has control over the installers, so that just needs to be an extension within the licence of that control.
What evidence do you have that the installers are direct employees of the fabricators? My understanding is it's a highly casualised industry, and that most of those installers are likely to be subcontractors.
They're either I haven't got exact numbers, but my understanding from the evidence that I see from conversations is that they're either an employee, or they're a subcontractor, but they're controlled by the fabricator. So the fabricator has as far as we're concerned, the conversations we have with fabricators, it doesn't matter whether they're a subcontractor or whether they're an employee, they're controlled by the fabricator.
Having an employee-based licensing system as well as an overlay surely would overcome any of those control issues that might come from not having direct employees subject to specific control by an employer.
As long as the subcontractors were also under that scheme, as an extension of the fabricator's requirement to be licensed.
I'm happy to pass the baton over, Chair.
Thank you, Mr. D'Adam. We've only got a few minutes left. I'm going to give Mr. Martin the opportunity to ask any final questions, and then we'll probably draw the hearing to a close.
Yeah, at the risk of getting too technical, how do you actually create a low silica product? What's used in place of it?
There's different ingredients used. We're using a product called feldspar, which is quite an abundant product, and so far with all our testing, and we're at final stages, it doesn't change the nature of the product. We've used it historically, so we're used to using it. We understand the issues associated with it, so we've adjusted for those, and we're more than quietly confident. We're in the final stages of production.
All right, thank you.
Thank you. Mr. Amato, did you have any final questions?
No, I'm fine. Thank you, Chair. Actually, John Taylor Martin just asked a great question.
I'm sure he will be very. I'm sure he'll be very pleased with your commentary about his quality of questions. Mr. Buttigieg, I can see you are indicating, so I'll allow you to ask one more question, and then I'd say we'll be drawing everything to a close.
Thank you, Chair. Just to tie up the conversation, I guess, can you understand the people looking at this problem and making the analogy with asbestos and the trials and tribulations we've been through over that product, and 10, 20, 30 years down the track, people saying, why didn't we take this out of the input to the economy when we had the chance? Now, I ask that question in the context that, are you confident that this licensing regime, training, PPE, preventative measures, will reduce the risk to a point where we won't be asking ourselves those questions in 10, 20 years' time? Because Mr. Shoebridge's questioning was quite pertinent, I think, in respect of the insurance industry not being prepared to cover you for those sorts of things. And, people put their money where their mouth is. So that is a significant, as he put it, red flag to me to say that the market has priced this in and doesn't think there is an acceptable risk. What do you say to that?
I'd just say a couple of things. I think, reflecting on the insurance side, the average claim is around $2 million to $2.5 million. So I think, reality would be, I'm fairly confident we could get insurance, but the excesses would be non-commercial. It just wouldn't make sense. So I think insurance companies look at it and say, well, okay, the likelihood of us taking up that sort of excess is not going to happen. As such, it's probably not viable to have insurance for this issue because of the cost. However, we're highly confident based on everything we've seen in the industry, particularly in the last 3-4 years and more so the last 2 years, of the changes that we're seeing with fabricators. We are seeing consistent change, we're seeing recognition, we're seeing awareness. And, from an asbestos point of view, this is not a consumer issue. The product is safe in my warehouse, it's safe in your home. It's just what happens in between with the cutting and the polishing and the installation. And we have to make sure that that's handled the way it needs to be. And our evidence is, and our belief is, the product can be handled safely. So there shouldn't be a consideration to banning a product that could be handled safely. There should be consideration to enforcing the requirements, which we believe make sense through a national licensing scheme.
Thank you for that answer, Mr. Cullen, and I'd like to thank both gentlemen for joining us this afternoon. For answers that have been taken on notice, the committee secretariat will be in contact with you to liaise and ensure that they're tabled within 21 days. So that brings this afternoon's hearing to a close, and I'd like to thank all participants for their attendance and candour. Thank you.